Lordship, may be permitted to mention one matter. Lordship, a week prior, I had already mentioned this matter before your Lordship regarding one civil revision being filed challenging one order dated 26th of April 2024 before Barrackpur Court, and subsequently one CO was filed before the Honorable Court. Now, what has happened on 18th of July, the CO got dismissed since the advocate in record was suffering from ill health, and thereafter one a restoration application was filed before the Honorable Court. Now, in the meantime, what has happened? The opposite party has already filed one section 45 of the Guardians and Wards Act before the court, the court below. And what has happened? The learned court below is not granting us any stay since the CO is not heard, since it is still pending before the Honorable Court. Your Lordship, may I read?
Not whose determination?
Lordship, the Court 5, Justice Procedural.
Lord, may I have my Lord's leave to mention, my Lord, listed motion, the list of Justice Vivash Ranjan De, my Lord has determination today, my Lord. Item number 80. The urgency is the bank will take possession of my property tomorrow. But there was an order passed by this court which permitted me to move the DRT. I moved the DRT. The DRT, by an order dated 2nd of December, dismissed my Section 17 application holding to be not maintainable. The DR80 is not sitting for the week. This matter urgently. They are supposed to take possession of the property tomorrow. Punjab National Bank. Item number 18 in Justice.
এই লাগাবে না স্টিকার গুলো লাগিয়ে রাখলে সুবিধা হয় কোথায় পেজ নাম্বার where is the copy of the where is the copy of the notice?
So the copy of notice is not there. The DM's order has been annexed to the application.
No, it is going to execute the order. Where is that notice?
The DM's order has been passed. I moved the High Court. The High Court permitted me to go before the DRT. Now, since the matter was pending for the DRT, they were not taking steps. Now, on 2nd, the DRT matter got dismissed. Now, the police comes to my house and tells this week, the Saturday will take possession, because this is the Saturday when the bank is working.
They have given some notice that such and such date this.
They don't give notice. Once the DM's order has been passed, this goes to the local PS. The local PS is not supposed to give me any notice. In fact,
any local PS is to take any action, any notice has to be given to the.
That is in terms of the DM's order. The DM's order says at page 120.
They cannot come any day and take possession. There has to be a notice.
That's the way it is.
Where is that notice?
Kindly see the DM's order. 121. But I mentioned this before Justice Vivash Ranjan De, on 4th. This lordship was pleased to fix it today. Lordship is not sitting today.
But 80, there is no mention that it will be taken up today. 80, item number 8.
18.
18.
Motion.
18.
18. Court number 20, item number 18.
Supplementary bar karo di.
The file has to be brought from court number 22. Allows the mention, kindly permits me to. The DM's order has not been served upon me, my lord.
Which page is the DM's order?
117, I guess. The DM's order has not been served upon me. There's one 13th September order. Then there's the order passed by this honorable court. They're not even serving the copy of the order. It's only when I came to the High Court that the High Court asked them to serve a copy of the order to me on 7th of October.
Whether co-shares of property can be asked. You are the co-sharer?
I'm not co-sharer. So the partition is pending in the High Court, in the Alipur Court. I am neither the guarantor nor the borrower. And therefore, they say I'm not entitled to any notice.
But the entire property has been mortgaged.
Yes.
How?
But that's the situation why I was challenging before the Section 17 court, the DRT. But the DRT dismisses my application saying it is not maintainable, but by limitation, despite an order passed by this court asking me to go to the DRT.
Okay, this is passed in writ petition.
When I approached this Honorable High Court, the Honorable High Court permitted me to go before the DRT. I go with the DRT dismisses my application as not maintainable.
Okay. Supplementary list. Supplementary list. Put the minute supplementary. Record on. আমাদের রেকর্ডের সময় আছে দেখো ওই সেকেন্ড হাফে যেটা অরিজিনাল সাইড আছে আমরা 12:30 করতে পারবো না 12:30 12:30 12:30 ও 12:00 সময় করে নিই সেকেন্ড হাফে অরিজিনাল সাইড থাকবে অসুবিধা হবে 12টা করে দাও 12 করে দাও
I'm so grateful.
So if I were to mention a contempt application, my lord's order. Then everything,
My lord, may be allowed to mention, my lord, item number 21 of the Honorable Justice Court of 22, my lord. Extension will be order, my lord. My lord, the matter is not 9 parents were understood below, my lord.
9th you mentioned before the court. What is this one? You consider the representation. Give a notice and mention. Notice the other side. Give a notice to the respondent.
no, my lord, it is contempt matter. I cannot direct, my lord, unless with direction by the honorable court. My lord, I cannot serve the, my lord, cannot serve
Please
the.
go now.
Allowed to mention, my lord. Item number 21 of the Honorable Court of 22, my lord. Extension of district model, my lord. And he said, I cannot mention, my lord, the option was big. Because, my lord, it's the suit that is taken on 9th, my lord. The petitioner is the dependent, and the suit is filed by the plaintiff. And tomorrow,
Interim order expired.
my lord,
When?
my lord,
When did the interim order expire?
until further, this is the order passed by Honorable Justice November or until further orders.
Where is the order?
Your lord, my lordship, that any time out today, because
Not
matter was yesterday mentioned to the honorable court and
Where is the order? Extension order.
you are.
Oh, no.
এটা তো হ্যাঁ
Okay, list doc.
item number 1.
Shows that you are not carrying the order. This is your urgency.
But it will kindly fix any time, manner in the next time, manner.
You're not carrying any papers and mentioning the matter when the order is in court. I have to see it through the. I have to check out the order is. কবে অবধি আছে এক্সপায়ার করে আছে ঠিক আছে নিয়ে নাও কেউ নিয়ে নাও সাপ্লিমেন্ট 16 করে 12টার সময় Come at 12. The other side has appeared in this matter. Huh. Okay. Come on 12, we'll see. At 12.
Well, for the petition, kindly sees your lordship's last direction. I have not been served with. There was a direction by your lordship to serve it advance copy upon me so that I can give the reply to that opposition. I have not received it. However, I am submitting the opposition to the application filed by the respondent. 7 and 8. I'm giving a copy.
I don't need to give a reply. Whatever there is, I have to see here. There is no the provision. There is no the direction for giving any reply to the report.
Yes, it is there, my lord. In the last order, my lord,
Reply
there
to
was
the report.
advanced copy was to be served upon me to enable me to give the response to it. As now I am receiving this. Kindly see your lordship's last order. But I have prepared the affidavit in opposition to the application I have submitted before your lordship today. All right, give me some time so that I can.
Where is your report?
The direction to give it on 2nd upon me. Right now I'm receiving this.
They are the content is there, but required is not. There is the land that has been already. That is their case. We have not.
I'll be placing my case. I'll be placing my case. Yes. So there is an interesting development now. On the lands, there were the boards fixed by the PDCL. In Bengal, it is written Jomi Odikron Kora Hoyache, PDCL. Suddenly, we found I have annexed those documents. Those boards have been wiped out. Now it is being written Jomi Odikrito, Government of West Bengal. Now, what is the status? PDCL is no more holding the land. Has it gone back to the government? I've given these documents. Now, there is a substantial change. Photographs are annexed. Those documents which were requisitioned 66 years back, there was a poll and board saying that Odikrito PDCL. Now, that has been wiped out, painted, rewritten. Land belongs to the government of West Bengal. There is no name of PDCL now. Now, this is development. Now, what should I understand from the state's affidavit? I need to controvert that. It's the latest development I've brought to the notice of the court. But kindly gives me some time so that I can controvert because they are categorically stating against us. So I'll be prejudiced and they have annexed the documents. I need to go through the documents. What documents they have annexed?
No.
It says any day subject to lordship's convenience. Giving me some time so that I can prepare it and I can bring my clients from Purulia and affirm it again. Only one request, my lord. 10th and 11th, my lord. 10th and 11th will not be available, my lord. Kindly, if your lordship takes any day before 19th, I have no problem, my lord.
Thank you. Next.
Subject to lordship.
12, 13,
Absolutely, no problem.
9,
No problem.
whichever is
No problem.
12 की बात है 12 देखो ना डेट कॉपी दो देखो
Any day, no problem.
Civil ID learned advocate for the petition আচ্ছা তার আগে দিয়ে দিন affidavit in opposition to the application of the respond number 7 and 8 filed by the petition is taken on record. A report in the form of affidavit. Next slide again. Report in the form of affidavit filed by the state respondent is also taken on record. Copy served. Mr. SP ID, learned advocate, submits that since advance copy was not served upon him, he needs some accommodation to file exception to the report filed by the state. Let such report, let such exception be filed by the petitioner by 12th December. Raise this matter on 12th December.
Very good. I'm grateful. Well, kindly
12th
request that I have handed over the affidavit in opposition to my learned
Item number
friends.
2.
Kindly record,
Copy
sir.
served. Affidavit in opposition, copy served.
File, well, kindly takes into record that I have submitted affidavit in opposition before your lordship today.
Exception may be given for copy supply.
I have supplied.
No,
Exception I'll be definitely. Well, kindly takes into record that I have submitted today the affidavit in opposition to the application.
Item number 2.
National Highway Authority of India. The last date I have been served with copies of the applications. Delay continuation applications, Your Lordship. Again, so far as the substitution application is concerned,
Which are the substitution and which are the one is restoration? Can 2 is which is delay, counter-restoration delay? 1.
can 1.
3 and 4 are
3 is again a section 5 application for continuation of delay.
सब application में आजा तो
4 is for restoration.
2, 3, 4. हाँ. बोलो.
So far as can 2 is concerned, that is the
1.
substitution
Counter-restoration
application.
delay.
The petitioner has
substitution.
stated that the petitioner number 1 passed away on 2nd October 2021. He left a will. The applicant who has to be substituted in place of the petitioner is the person who shall be substituted in his place for the purpose of dealing with this matter. Paragraph 3 of the application. Your Lordship.
1.
Yeah.
Oh,
Paragraph 2 and 3.
due to the wheel, which has been reached.
Probate proceedings are still pending. It was submitted that till the probate petition is decided, perhaps the applicant cannot be substituted.
I
Till the probate is
judgment, my lord. Detect, my lord. Tendency of the process. This is year 1980 Calcutta 1.
Really?
Paragraph 7 is there.
This is separate, no? Facts are different.
Was allowed. Once it was died,
Although the will was not their representative decision. Page 11 says that they were the legal representatives. Even if the will was not provided, being the legal representative, they were substituted in this suit. This is not the case over here. What is the stage of the proceedings? Then either get the proceedings concluded and thereafter move this application or reject this application. Because as on date, he has no locus standi to file this application. You annex the copy of the will. Have you annexed it? No. Who is this petitioner in place of petitioner? Noro Singh, petition number 1. And who are 2, 3? Who are the other petitioners?
None of the other petitioners are represented, and the matter was dismissed for default, and thereafter nobody has filed any application for restoration.
Until and until the substitution is made, the restorations are not. Also, when the learned advocate for the petitioner submits that applicant submits that the petition number 1, Narasingho Prasad Gupta, expired on 2nd October 2021, and he has during his lifetime has executed a will. The applicant is the executor, and he will execute a will. Executed a registered will dated 2nd January 2015. Where this name of Anil Saha is coming in the will. Will executor and appointed the applicant Anil Kumar Saha as the executor. the applicant has filed an application for grant of probate before the Court of Civil Judge Senior Division First Court, Court of before the Civil Judge Senior Division First Court Malda, being this case number 21 or 2021. And the said proceeding is still pending. We seek some accommodation to move the application after grant of probate. Let the matter go out of list with liberty to mention. এটা দিয়ে দিন।
Item number 3. I am appearing for the petitioner, my lord. I am appearing for the petitioner, my lord. Lord, three connected applications are pending, my lord. And one, my lord, is a application relating to the restoration of the writ petition, which was dismissed on 28th September 2022 by the order which was passed by the Honorable Justice Shubhra Ghosh, and thereafter the CAN application number 2, which is the application relating to the condonation of delay, and CAN 3 is an application which is a restoration application of the CAN 1, which is also dismissed on 14th May
Restoration
2024.
application for
Yes, my lord.
restoration of CAN 1.
The CAN 1 is the application restoration of the main writ application, my lord.
So both the applications has been dismissed. CAN 1 and CAN 2.
Yes, my lord. CAN 1 and CAN 3, my lord. CAN 2 is a condonation of delay.
CAN 3 is?
CAN 3 is a restoration application of the first restoration application, my lord.
So by CAN 3, which are the applications to be restored?
By the virtue of the CAN 3, my lord, I would like to restore the CAN 1 application, which was dismissed on 28th September 2022, my lord.
Not CAN 2.
CAN 2 is an application relating to the condonation of delay, my lord.
Restoration application within time?
My lord, CAN 3 has been filed within time, my lord. And
No,
CAN
the
1,
restoration application was within time.
my lord, CAN 3 is a restoration application which was filed, which has been filed within a period of limitation, my lord. And the CAN 1 application has been filed with a delay of 540 days, my lord.
No, CAN 2, if not restored, then how can you condone the delay of the earlier application?
Yes, my lord. CAN 3 has been filed within a period of limitation, my lord.
By CAN 3, you intend to have restoration of which application?
CAN 1, my lord.
Only.
Yes, my lord. CAN 1.
CAN 1 is restored and heard. CAN 1 is barred by limitation.
CAN 1 is a, yes, my lord. CAN 1 is.
So CAN 2 will not be required.
Yes, obviously, my lord. CAN 2 is a application relating to the condonation of delay, my lord.
Restoration.
Actually, my lord, CAN 3 was preferred by the petitioner because, my lord, at the time of the calling.
Yes.
Because in this regarding 100 matter of painting, this is the same I'll in opposition,
You have filed your affidavit in opposition?
sometimes, but fine.
In 17, you have not filed.
That
That on the very same issue, appeal being met is pending a division bench.
Yes, the matter was first dismissed in 2022.
MAT has been disposed of. The MAT 1942 of 2016. Huh? One nine four disposed. Yes, sir. 1942 disposed of.
Actually, my lord, not yet.
Not yet. Can 3 of 2024. This is an application for restoration of Can 1 Can 1 of 2024.
Yes.
Comma filed for the restoration of the writ petition and Can 2 filed for condonation of delay in filing restoration application. Mr. Suensu, learned advocate for the petitioner, submits that the instant application is filed within affidavit of service over लिखे दिन टॉप पे affidavit of service filed on behalf of the petitioner is taken on record. Submits that the submits that and respect কেটে দিন submits that due to illness of the conducting advocate, the petitioner was not represented on the date the matter was called on. So the application is filed within the stipulated period. He seeks for the restoration of Can 1 of 2024 and Can 2 of 2020. Upon going through the averments made in the application, the cause shown is found to be sufficient to restore both the applications being Can 1 of 2024 and Can 2 of 2020. And accordingly, Can 1 of 2024 and Can 2 of 2024 restored to its is restored to its original file and number. How many days delay?
540 days, my lord. A delay relating to the Can 1 application.
And 2. What is the ground?
Actually, my lord, I have received the chain brief, my lord. And before receiving the brief, my lord, the advocate who was previously appointed by the petitioner was also not attending the matter due to any unavoidable circumstances, my lord. That's why the matter got dismissed. And thereafter, when the petitioner came to the knowledge of such dismissal, my lord, the petitioner, mother of the petitioner also died. And pertaining to such situations, my lord, the petitioner also may not mentally ready to deal with the court litigations as such the entire delay was happened.
Which paragraph you have stated?
Yes, my lord. I'm telling you, lordship. Kindly come at paragraph number 4 of the Can application 1. May I read, my lord? Yes. that in several occasions the applicant inquired about the fate of the writ application, but the learned advocate of the applicant in every time replied that the matter will taken up for hearing and very soon. But ultimately on 12th June 2023, on inquiry came to learn that the said writ petition has been dismissed for default on 29 September 2022, and the learned advocate of the applicant advised the applicant to take necessary steps. And thereafter, I'm reading the next paragraph, my lord, that on 26 2023, the applicant contacted with the learned advocate for conducting the case, and on 29th June 2023, the applicant meet with the learned advocate and gave some papers, but no copy of the writ application was not handed over to the learned advocate, because the copy of the writ on application was not available to the applicant, and for that reason the applicant petitioner contacted to one of the clerk for obtaining the certified copy of the writ applications. And thereafter suddenly on 1st July 2023, the mother of the applicant was died, and the applicant is unable to contact with the learned advocate for his family trouble. And after some recovery on 10th September 2023, the applicant contacted with some another learned advocate to conduct the case, but on 25th September 2023, the applicant petitioner himself became seriously ill, and the medical report disclosed that he is suffering from jaundice, and doctor advised him to take at least 2 months rest, my lord. And this is how the entire delay was happened, my lord.
Okay. Can do that. This is an application for condonation of delay in filing the restoration application. Mr. So-and-so, learned advocate for the petitioner, submits that the petitioner was not informed of the order of dismissal by his erstwhile learned advocate. On 12 June 2023, he came to learn of the order of dismissal. Due to the death of his mother, the petitioner could not take appropriate steps. Subsequent thereto, he also suffered from jaundice, which has resulted in delay of 540 days in filing the application for restoration. On perusal of the application, the ground shown is sufficient to condone the delay. Accordingly, delay in filing the restoration application stands condoned. Can 2 of 2024 is thus disposed of. The writ petition. Can 1 of 2024, after heading goes in, this is an application for the restoration of the writ petition. Upon going through the averments made in the application, the cause shown is sufficient. Accordingly, the writ petition is restored to its original file and number. The application, being Can 1 of 2024, stands disposed of. Mr. Retail. You are appearing for whom? Mr. Swansol, learned advocate for the state respondent, seeks to file affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within a period of 3 weeks. Reply thereto within a period of 2 weeks. Is this matter 2 weeks after the winter vacation? Separately. Why?
Every matter
So state will appoint the Advocate General to represent the state. And again, he will serve Advocate General. Advocate General will come. 2 weeks after the
Great. Item number 4.
4 is my application. But there are two cans, can 1 and can 2. Right? Can 1 was filed in 2021 for early hearing. Right? That has sort of become infructuous, right? That can be disposed of. And can 2 is a substitution application. But the writ petitioner number 1 died during the pendency of the writ petition.
state. Who is for the state?
But I've served. The state private respondent have served both the advocates. But the can 2 is a substitution application. But the writ petitioner number 1 died on 4th April 2024, leaving behind neither the applicants, that is his widow and his daughter, as his legal heirs and successors. Therefore, my lord, in my humble submission, my lord, the substitution application may be allowed, and my lord, the applicants may be made party in the writ petition as 1A and 1B.
Rutindra Narayan Ji. Hasan. Can 2 of 2024. This is an application for substitution of legal heirs and successors of petition number 1, Ashok Chatterjee, ASOKE. For upper the copy of later dated 25th November 2024, filed by the learned advocate for the petitioner is taken on record. Mr. Swansol, learned advocate for the petitioner, application for the petition submits that the petition number 1 2 is this 2. What is the relationship between 2 and 1?
But 2 is his cousin brother.
Submits that during the pendency of the writ petition, petition number 1, Ashok Chatterjee, expired on 4th April 2024. This is within time.
Yes, my lord, within time.
Leaving behind his son and
No, the widow and the daughter.
leaving behind widow Shikha Chatterjee and daughter Ishita Chatterjee as his only legal heirs and successors. The application for substitution has been made within the statutory period. He seeks for substitution of the legal heirs of deceased, petition number 1. Despite notice, none appears on behalf of the private respondents. Number 6 to 12.
Yes.
And the state respondents. It is found from the death certificate appended to the application within bracket annexure A that Ashok Chatterjee, petition number 1 Ashok Chatterjee died on 4th April 2024. It is contended that the said deceased petitioner left behind his widow Shikha Chatterjee and his daughter Ishita Chatterjee as her only legal heirs and as his only legal heirs and successors, which is more fully stated in paragraph number 5 of the application. In view of the above, let the widow Shikha Chatterjee and daughter Ishita Chatterjee be substituted in place of deceased petitioner number 1 Ashok Chatterjee in the cause title of the writ petition. Department is directed to carry out necessary amendments in the cause title of the writ petition by incorporating the aforementioned legal heirs of petition number 1 in the array of the petitioners. Let amended copy of the writ petition be served upon the private respondents as well as state. Application being Can 2 of 2024 stands disposed of. The other application you are
Other applications for early hearing. I had filed that during the COVID times, but that has become sort of infructuous. That may be disposed of without any order.
Can 1 of 2021, learned advocate submits that the application for expeditious hearing has become infructuous. He seeks to and may be disposed of. In view of such submissions, may be disposed of. In view of such submissions, Can 1 of 2021 stands disposed of as infructuous. They have filed their opposition?
Yes, everything is ready. There is a paper book containing all the affidavits.
Please, this matter 2 সপ্তাহ পর রাখি প্রীতম বাবু ভ্যাকেশনের পরে 2 weeks after vacation.
This will appear 2 weeks after vacation. 2 weeks after vacation. But a date may be given so that
কবে আসছে বলে দাও
16th January. Grateful to Lordship.
লিখে দিন 16 June.
Item number 5.
I'm appearing for the state respondent.
The evidence service manner. The restoration application dated manner 1st of April 2009. It was 8780/2019 before my last Can 1 month. And then subsequently it has converted to my last Can 1 month. Regarding Can application is concerned.
Within time, the application state green.
In time.
No, it is out of time.
My lord, the order of dismissal was of 1st of April 2019.
An application for condonation of delay has to be filed.
Yes, the application has been filed in August 2019.
It was mentioned in the application, my lord. They may be condoned, my lord.
Paragraph. What is the reason?
Possibly the reasons appear in paragraph numbers 5. 5.
5. 4 to 5. 4 and 5.
This is an application for restoration of the writ petition. State has filed its opposition, or
Lordship, I have been allotted the brief only recently. Possibly nothing has been filed in this application. If Lordship kindly grants us an opportunity to file an
was there any previous direction to file affidavits?
No, Malad. Report may be Malad file Malad, subject to correction Malad. Because opposition it will take Malad much more time. Because short matter Malad section 18 as well as notice I am challenging 9-2 and 12-1.
Lordship is pleased to restore the matter. Lordship kindly grants me an opportunity to file an affidavit in office.
Can one tool number to near na? Tool number to 8780/2019. This is an application for restoration of the writ petition dismissed on 1st April 2019. Mr. So-and-so, an advocate appearing for the petitioner, submits that due to change of determination on the date the matter was taken up, the petitioner was not represented, for which reason the matter got dismissed. He seeks for restoration of the writ petition upon condonation of delay. Upon going through the averments made in the application, the cause shown is sufficient to restore the application upon condonation of delay. Accordingly, writ petition, accordingly the order dated 1st April 2019 is recalled. The writ petition being number WP, WPA হয়ে গেছে 23376 of 2018 is restored to its original filer number. Can be number term stands disposed of. Writ petition a heading করে দিন Ms. So-and-so, learned advocate representing the state respondent seeks to file affidavit in opposition. Let such affidavit in opposition be filed within a period of 3 weeks. Reply filed within a period of 2 weeks thereafter. Is this matter 2 weeks after the winter?
Kyle take the time Malad. Otherwise Malad.
What time?
2018 matter Malad.
After 2 weeks, after the vacation.
I'm extremely grateful, Your Lordship.
3-5 to 2 weeks হচ্ছে তো
3 weeks will possibly lapse during the vacations, Your Lordship. Lordship kindly allows me to file the affidavit in opposition immediately upon reopening.
এটাকে চেঞ্জ করে দিন 1 week after the winter vacation,
I'm grateful, Your Lordship.
1 week thereafter. Reply. ওটা 3 weeks করেছিলাম তো 1 week after the winter vacation for like 1 week thereafter এটাই যে affidavit
Item number 6.
My lord, Lordship, yesterday I mentioned, my lord, showing 2 orders. The state is also required to file a report of compliance.
compliance report. Where is your compliance report?
Only this, who is advocate, who is not required.
There is a direction to execute the sale deed. What opposition will file? On the submissions of Mr. Mahata, this order has been passed.
Report in the form of
They were
affidavit
to
was filed.
find out whether the petitioners are entitled to the right over the land and thereafter execute the sale deed in their favor.
The Lordship kindly says the dates of the orders. Well, time after time, my lord, that has to be ended.
Who was to execute this?
The land acquisition officer. Land acquisition officer.
The disaster management, secretary disaster management is the, but the land has been utilized by the block development. So they are denying to give them. The fund.
Whatever be your predicament with the department concerned, that is to be sorted out by the state. What is the petitioner, why the petitioner will suffer for that? If they are not complying the order, then come up with that report that they are not complying. Thereafter, we'll see that which order can be passed. Just not responding to any report, not filing any report will not do. Once you have made your submissions and the orders has been recorded, you comply that order. Or else what is the no instruction? You inform the court regarding the status of that.
Compliance.
If it is complied, fine. If not complied, where it is stuck, that has to be informed. On the prayer of Mr.
Your Lordship kindly record an order, and so that I can intimate this order to the authorities also, because the state advocate will not take the responsibility.
Mr. Prasant Bihari Mahata, learned advocate representing the state respondents, seeks accommodation to take appropriate instruction in respect of the compliance report sought for by this court video order dated 23rd February 2024. Next week, তারপরের week একটা ডেট দিনে short একটা compliance report. 18, 19th এরকম হতো। 18th.
Item number 7.
Pursuant to the order of this honorable court, A joint inspection was conducted at the local. State has filed his report. It's a joint survey report. Joint survey report. Because of the petitioner, the acquiring body, and the requiring. The rail. I will say the report supports my case. People also kindly come to. People also have the copy of the report.
Report of
9th February 2024. Last occasion I handed over the copy.
this one.
The last page with a color map, sir. I mean, last page with a color map.
Color map.
Got it. Number may I read the first paragraph? First, my lord, kindly skip over the first. This is a communication. Number kindly come to the second page. Joint survey report in connection with WPA case number 17749 of 2013 in the matter of Sonjeev Baul, so and so. As per the solemn order of the Honorable Court, in respect of the above noted WPA number, I, being the LA Collector Birbhum, along with the railway official, visited the disputed plot number 1351 of Mauja Horishara, jail number so and so, on 24 January 2024, and the signatures have been obtained in the separate Hajira sheet conducted surveying of the plot in front of the writ petitioner, Mr. Sonjeev Baul, with proper notice served upon the bottom. Next paragraph. After searching of the official document, it learned that the disputed plot related to the revised LA case number so and so, that this is to inform that 82 decimal of plot in question was acquired and revised LA plan is lying with the office. The measurement has been done as per the alignment of the basis of the revised LA plan, and accordingly, the railway official have picked the demarcation line after surveying of the disputed plot in the front of petition. The hand sketch map is prepared on the spot and signature of the resolution, and all parties are satisfied with the way the determination is made. It is observed that there is no encroachment by the railway. Now, my lord, if you will also kindly look into the affidavit in opposition used by the state government. That's number 2 and 3 in opposition.
When it is filed? Earlier or recently?
It's served upon me. Paragraph to the it's not with the lordship. But this was served upon me. May I read for him for your lordship? But that's the one paragraph. Someone also can you look into my copy? Can you look into my copy? It was served upon me.
Did not file what is to look into. They are not part of the pleading. When it was filed? Who filed the supplementary affidavit?
I filed my supplementary. Well, if you also can you look into my supplementary affidavit once? But then it's not required to see into the opposition of us. But kindly look into my supplement. Now, kindly remember the plot number was 1351. Now, kindly come to page 6 of my supplementary affidavit.
Yes.
It's a notification of 1966 Whereas the function of the central government under the Land Acquisition Act in relation to the acquisition of land for the purpose of union with the state of West Bengal have been entrusted to the government of West Bengal by notification dated so and so 1955, issued by the government of India in the Ministry of Home Affairs under the clause so and so, Gazette number. Now, therefore, in excess of the power conferred by Section 48(1) of the Land Acquisition Act I-1 of 1894, the governor is pleased to withdraw from the acquisition of a piece of land starting from mile 121 to mile 122 of the Sahibganj loop line, comprising part of cadastral survey plot number 1343, 1348, 1349, 1351. But this 1351 is my plot. Of Moja, Horishara, jurisdiction list number 1, police station Saithia, and parts of Katamala others have been given. Initially, land acquisition process was initiated. The government had decided to acquire my land. Whether notice has been issued, steps have been taken, but ultimately the land was disacquired by this notification. But the railway has used my 82 decimal of land out of total 160 decimal. But that is my case. And this report of the state is supporting my case. Admittedly, rail has used 82 decimal land, whereas the land has not initially acquired, but subsequently by notification, it was disacquired. And when this issue has been dealt with by the in opposition, thereby admitting by the state that yes, the land was acquired, subsequently disacquired. But in their report, if your lordship kindly look into, in their report, they have annexed the notification of the government, that is page 1, 2, 3, 4, 5, 7th page report. It's dated, notification dated 20th February 1964. 7th page.
Report of state?
Yes, my lord, report of state.
Which one?
The 7th page. This document.
Yes.
But this is dated 20th February 1964. Well, by this document, the acquisition process also started, where the function of the central government is given and where it appears that to the government, land is likely to be needed for public purpose, namely for construction of double line on the Sahibganj loop line between Saithia to Haroa from 121 mile to 123 mile in village of 1 Horishara, jurisdiction list 1, police station Saithia, Parulia, Pathai, Hosenganj, jurisdiction list, Mayureshwar district, Birbhum. It is hereby notified that pieces of land comprising the cadastral survey plot as detailed in Schedule A and B below and measuring more or less 2.605 acres, 2605 acres, are likely to be needed for the aforesaid public purpose at the public expenses within the aforesaid villages. Number Schedule A, the cadastral survey plot number 1343, 1348, 1349, and 1351. That is a disputed plot. Number, kindly look into the said document and the document annexed by me in my supplementary affidavit. All plots. Acquisition process was withdrawn. In paragraph 2, similar project, loop line from mile 121 to mile 122 on Sahibganj loop line, comprising parts of cadastral survey plot number 1343, 1348, 1349, and 1351. The 1351 is a disputed. Well, that is the reason in my lordship, the record of right, that is page, just 2 pages before of the report, in the report. So you can see the record of right, just 2 pages before. Right, got it?
In the report?
In the report. First, second, 4th page.
Yes.
Number, kindly see the record of right. Dag number 1351. total is 1.80.
This page, this one.
Just prior to that. Just prior to that. There's no page mark that is a difficult. Fourth page from the
Fine. এটা দিন স্যার।
may I mark in pencil one?
No, not required. You hold that page.
But this has not been given to your lordship. Telling me the but it is also annexed in my intention. It's page 24. Kindly see, that is the reason the land record of rights is still in my name. The entire my lord, 1351 is 261, and now it's in my name. Already, it's a report. Report it was in my name of my grandfather, who purchased it, bought and sold it. Subsequently, it is recorded in my name.
As of now, there is no encroachment.
There is no, the entire plot is encroached. The entire plot has been encroached. But the state has says after inspection, they found there's 82 decimal of land used. And I have demonstrated before your lordship that yes, there was the acquisition process in 1966, which was subsequently withdrawn by way of a notification, and the entire land belongs to me. So I'm entitled for the compensation from the railway, because the railway has used the land. State has not acquired the land. State says I'm not acquiring the land.
No, question is acquired.
Of the other portion of the land.
Yes, but
prayer portion.
Yes, 0.98. I've said 0.98, but it came to learn that yes.
1.8 acres lost, 0.98 acres of land into subject matter of this expedition now.
The state says not 98, 82.
Highly disputed question of fact. Joint survey has been held in presence of all the parties, and it has been found that there is no encouragement by the railway. It is point of that matter by Lawrence Helper is facing for the release more and the retreat. Actually, as a matter of fact, all such issues could have been.
But may I submit one thing, my lord? Let a report be filed by the state whether the land has been at all acquired or not. Whether this document I've showed to your lordship that the acquisition process has been withdrawn, whether it is still in process or not. Because acquisition process of 1964, subsequent withdrawal is 1966.
report. It is your report.
আমাকে একটা কপি দিন। Yes, but I'm satisfied. I have said 98 decimal of land are encroached, but after inspection it's found no, 82 has been used. And I've demonstrated before your lordship that the acquisition process of 1964, which was in 1966, which was withdrawn. And the this document, till today, neither an opposition has been filed by the state, thereby disputing this document, my supplementary affidavit.
After the order notification dated 1966, the land was handed over to the petitioner. Have you got any document after the governor has withdrawn?
That could not be asserted after law.
So your report is not specific of anything even except that the state says that there is no encroachment. What is the records of the railways after the notification dated 1966? Forget about it. If the state says that 82 decimals of land were acquired and the notification of 1966 shows that it has been withdrawn, that means entire land should go to the petitioner. So this process has been initiated and they have been handed over their land, which was acquired by the railways. Here. The dispute now is of 82 decimals. He has paid for 98 decimals, but 82 decimals you say that it was acquired. He has shown a notification that entire land was withdrawn. So the entire land should go to him. What was the total land measurement?
1.80. 1.8.
It should go, including the 82 decimals, if that is disputed. Where is the document that has gone to him? Now he is in possession of that land. The railway has not used it.
Which possession of the land, that can be ascertained. But the thing is,
you are in possession of the land?
No, 82 has been, they have used the land for the purpose of construction.
Yeah, categorically stated.
Well, the railway has been,
The occupation of the land.
well, the report says, sir, I mean, report says out of 1.80 acre of land, 82 acre of land has been used by the railway for lots of for railway line, a double line. Now, my prayer in the petition that no 82, there was 98. But after inspection is found, no 82 has been used by the railway. The railway says in 1964, via a notification of acquisition, the said 82 land, 82 decimal of land was used, was taken away. But in 1966, in subsequent notification, the acquisition process was withdrawn. And that is the reason the entire land is recorded in my name as on date. Since the land was handed over subsequently, but railway has forcefully used the entire land. That is the reason I filed the petition, and I prayed for an interim order not to use. And there was an interim order passed by this honorable court. If you also kindly see the interim order passed by this honorable court on 28/11/2013, there's an interim order passed by this honorable court, thereby directing the railway not to construct any railway line. But in spite of that, they have constructed.
Is there any structure of the railways over
Yes,
this land?
the rail line, but the report says, can you see the second page of report? Report says so.
Plot number?
As per solemn order of the Honorable High Court, in respect of above noted writ petition, I being elect collector Birbhum, along with the railway official, visited the disputed plot 1351 of Moja Horisara, jail number so and so, on 24th January 2024. And the signature has been obtained in the separate Hajira sheet, conducted surveying of the plot in front of the writ petitioner, Mr. Sanjeev Baul, with proper notice served upon them in connection with the construction of double line on the Sahibganj loop line between Saithia and Burhara from mile 121 to 123. After searching the official report document, it is learned that the disputed plot related to revised LA case number so and so 1963-1964. From this LA case, there is to inform that 82 decimal of plot in question was acquired and revised LA plan is lying with this office. The measurement has been done as per the alignment on the basis of the revised LA plan, and accordingly, the railway official have picked the demarcation line after surveying of the disputed plot in front of the petitioner. The hand sketch map is prepared on the spot, and the signature of LA officials, railway officials, and Sanjeev Baul, the petitioner, have put signature in the sketch map, and all the parties are satisfied with the way the demarcation is made. It is observed that there is no encroachment by the railway. Now, let kindly see the
What is this dotted line?
yes, the dotted line. They have annexed with their report. The next page. The red dotted line used by the railway, which is 82 decimal. The total 1351 plot number, red dotted line used by the railway.
The red dotted line on the right hand side. This portion.
Yes, this portion. Just
This
beside
one?
the rail line.
This side.
This side, madam. You see the rail line? This portion has been taken by the railway. Yes. The rail line is passed there. Right hand side of the red dotted line. Left hand side.
This has been used by the railways.
This has been used by the railway. They say this is not encroachment since there is the acquisition process. But I will say the acquisition process was there, which was subsequently withdrawn.
Oh.
So later report is submitted by the state. So what is the status of this 82 decimal? Whether that is at all withdrawn or not.
Or whether it has been used by the railways or not.
Yes. It is to be also submitted by the railway also.
No, then you hand over the 82 decimals of land.
That was in 1960s.
If you say that you have not encroached, you say that you are not being using that, and they have raised the issue that that land is being used, I say that you hand over the land. Deliver the possession of the land to the petitioner.
Then can you declare to that effect? Can you declare to that
Then you
effect?
come up with a report which is of 1351, whether you are using any part of 1351 or not. That is the concern. There should not have been any encroachment. There should not have been usage of any of the plot of 1351 since it was withdrawn. If you are using that, you are not authorized to use that.
Come to page 29 for a moment. They have used a letter of the
Sir, the simple thing is that you being an authority, you inform the court whether you are using the land or not. If no, then come up with your report that you are not using that. Not that whether you are encroached or not, because that order by subsequent notification has been withdrawn. So you have no authority to use the plot 1351. As simple as that. If you are using, hand it over to the petition. Let him take his land. File a report whether it has. Mr. Chittopriyo Ghosh, learned advocate appearing for the petitioner, submits that the report filed by the state clearly indicates that 82 days. Joint survey reports filed by the state respondent clearly indicates that 82 decimals of the plot in question was acquired. The railways have been using such land without any proper authority since by a subsequent notification dated 20th February 1966. No, this is 66.
66 here, which one? It dated 23rd August 1966.
23rd August 1966. The acquisition was withdrawn by the governor. Upon perusal of the report of the railways, it is not clear as to whether the plot being 1351 is actually been used by the railways. The state respondent as well as railway authorities is to file a detailed report as to whether plot number 135
1351 or
1351 is being used by the railways to the extent of 82 decimals of the land as is depicted in the report, joint survey report of the state respondents by the returnable date. Is this matter
January month is well.
in the monthly list of January? পরে এটাকে ঢুকিয়ে রাখুন রিপোর্টে।
Much obliged, right?
আমাদের কি ওই রেকর্ডস গুলো এসে গেছে? নেক্সট দেখে দাও।
Order passed on that date, my lord, in 11th.
What is this CAN 1 of 2024? This is an extension application. You did not file. তাহলে কেন হয়েছে? K application is there.
Yep.
ওটি কেন হবে কেন? আচ্ছা দেখে দাও।
But admittedly, my lord, the petitioners are the co-shares of particular premise, which has since been mortgaged. Admitted, my lord. Now, my lord, page 117, if my lord kindly sees, page 117 is a notice to vacate the property by the Punjab National Bank, my lord, the opposite party. Let's seize the names of the persons, my lord. Anirban Mitro and Mrs. Amrapali Medical Center and Nursing Home. So, my lord, the issue today is, my lord, this Amrapali Medical Center had availed of a loan in which, my lord, this premises was put as a collateral security by an individual who was also a co-share of the property.
And the director of the Amrapal.
About now, let kindly seize the notice with reference to order memo number such and such dated 10/8/2020 and the Honorable Magistrate South Chobbish Pargana and change of magistrate order memo number 543/1/4 such and such dated 4/3/24. You are requested to vacate the below mentioned property on or before 18/9 and hand over possession of secured assets. So, my lord, in terms of an order, possession of the property would be taken. This is the sum and substance of this notice. So, my lord, see, there are two memos. One is a memo dated 10/8/2020 and the other memo is a memo dated 4/3/2024. The moment I received this on 13/9/2024, my lord, since I had not been given a copy of either of these two memo, my lord, I moved this honorable court under Article 226. The order passed by this honorable court appears at page 118. Next page, 118. Let's see, two issues were raised. The first was whether the co-shares of the property could be asked by the bank to hand over possession of the property in the absence of any order against them. The other issue is whether non-service of district magistrate's order would create a right upon the co-sharers to challenge the steps taken by the bank by filing a writ petition. Mulad will kindly note, in this writ petition, Mulad, appearance was entered on behalf of the bank. So this matter was being heard in the presence of the bank, and this is within the cognizance of the bank that these are the issues. Mulad, thereafter, Mulad just takes the next page, Mulad. Those were my submissions. Kindly takes, Mulad, page 119, the last paragraph, as to what the bank has to say. Page 119. Started from 118, it's just the next page, Mulad. What the bank has to say. The learned advocate for the bank submits that in paragraph 8 of the writ petition, the petitioners admit that the order of the district magistrate was served on the original borrower. But I don't shy away from that. So it was served on the original borrower who had mortgaged the property. The claim of petitioners as co-sharers is the subject matter of a civil suit, but no decision has been arrived by the civil court. But this was the submission. So it is also to the knowledge of the bank that the partition suit is pending. Now, my lord, then the property was mortgaged by the borrower. So bank knows everything. Next page, my lord. The fact that the property was mortgaged is not in dispute. The petitioners are aggrieved persons. Any aggrieved person can approach the Debts Recovery Tribunal under Section 17 of the SARFAESI Act. The petitioners have the liberty of doing so. So, this honorable court grants the petitioners the liberty to move before the DRT. Then, the petitioners have liberty to do so. The petitioners shall approach the tribunal in accordance with law. A copy of the order of the district magistrate has been handed over by the learned advocate for the bank to the petitioner's advocate record. So, kindly sees the date of the order, at page 118. This is 7/10/2024. So, in 7/10/2024, page 118, the order starts on the left-hand, top left-hand, is the date, 7/10. Page 118, top left-hand corner.
Just a minute, just a minute. Hey, Preetham.
Seen the date at page 118 is 7/10/2024. Now, this honorable court records that the order of the district magistrate has been handed over by the learned advocate for the bank to the petitioner's advocate record. So, on 7/10/2024, I get a copy of the order. Then, as there is a specific government writ petition that the original borrower was served with a copy of the order of the district magistrate and the order remained unchallenged, the issue of limitation will be decided by the DRT. All points raised by either party are kept open. Then, there's an interim order which says bank will not take coercive steps as regards possession till a particular date, writ petition disposed of. In terms of this, I move a Section 17 application before the DRT. That would start at page 31 of my application, and the reliefs are at page 53. Let's see page 31. My application starts, the cover pages, the customary cover pages. The main petition starts at page 35. Let's see, Siddhartha Mitra and Nivedita Ganguly happen to be the petitioners. They filed this Section 17. Now kindly comes to the reliefs at page 53.
Yes.
The reliefs kindly sees page 53, reliefs sought. Let's see the first relief at page 54. Really famous. Order to issue that the said property more fully described in this paragraph 5.1 is not a secured asset within the meaning of section 2ZC of the Surface Act. So, I have challenged the issue as to whether the property is mortgaged at all or could be mortgaged at all. Next, kindly sees order to issue declaring creation of security interest on and or in respect of the said property more fully described in such and such is illegal to the core and unlawful and accordingly illegal or void. Do issue declaring respondents not entitled to measure under the Surface Act for the purpose of enforcing security interest under the said property more fully described. Then D, order to issue setting aside the order dated August 10, 2020 passed by district magistrate. So this is this order which was handed over to me on 7th of October. Then an order to issue commanding restraining respondents from giving effect and the further effect and from acting on the basis of the August 10 order. So I have challenged the entire action, the mortgage, the entire action as well as the DM's order. Entire thing is challenged. Kindly sees the limitation. The limitation ground is held at page 37, which is paragraph 4.
Yes.
Now kindly sees limitation. Records would reveal that the order dated August 10, 2020 as contained in memo number such and such and an order dated subsequent thereto dated July 19 as contained in memo number such and such passed by the district magistrate district 24 Pargana South purporting to be an exercise of powers allegedly conferred upon him under section 14 of the Surface Act was handed over to the applicants on October 7, 2024. During the hearing of an application under Article 226 of the Constitution of India, preferred by the applicants before the Honorable High Court, since registered at such and such, vide a solemn order of event date, that is October 7, 2024, liberty was granted to the applicants to approach this tribunal with an application under 17. Then, my lord, I say, it is tried that limitation would be reckoned from the date of knowledge of the person referred to in subsection 1 of section 17 of the Surface Act. Present application is filed within the period of limitation under 17.1. To this, my lord, I will be relying upon judgment passed by your lordship's court, holding as to when the limitation should start. So this was my application. So my lord, now my lord kindly takes the page 34, kindly takes up page 34 as to what were the documents which were before the DRT along with this application. Page 34. The list of enclosures starts from page 33 and page 34, kindly see serial number 12. A copy of order dated 7th October 2024 passed by this Honorable High Court. So this was also before the learned presiding officer and tribunal below. Now, my lord, the tribunal now passes an order saying that my application is barred by limitation. Kindly takes the impugned order, my lord. The impugned order, my lord, is dated 2nd of December 2024.
Page number.
My lord, it is on the certified copy is annexed, my lord. The last 3 pages of my lord.
Yes.
Let's see. NDN such and such is taken back for hearing because it was not registered as an not registered as such, so this NDN diary number comes in. Heard the learned counsel for the applicant. The applicant is seeking limitation from 7/10/2024 when the order dated 10/8/2020 as contained in memo number 779/Surface dated 10/8/2020 and an order subsequent thereto dated 19/7/2022 as contained in memo number such and such passed by the DM, South 24 Pargana was handed over to the application. I fail to understand what is the gamut of this line. But no copy of the subsequent order dated 19/7 has however been annexed to the record. If the bank hands over only a copy of the DM's order, then my case right through has been that I have not been served with any orders. So if the bank hands me a copy of the order of 10th of August, how am I supposed to have a copy of the subsequent order as well? So kindly sees the order passed by this Honorable Court, page 120.
But DM's order was served upon the borrower.
Yes, and I'll show it from the DM's order itself. My lord, kindly takes the DM's order. The DM's order.
So your case is on 7th October.
Yes.
You were served with the order.
Yes.
Prior to that, there was no knowledge.
Yes.
Yes, carry on.
Well, the applicants claim themselves as co-shares with respect to secured asset. Well, it's admitted position. It is alleged during the course of hearing that no copy of the learned DM's order dated 20/2/2020 being memo number such and such was served upon the applicant. Well, kindly comes to page 123, which is the DM's order. Well, page 121 is a DM's order. Well, kindly comes to page 123. As to on whom this order was served. Got it, page 123. Kindly sees copy forwarded for information necessary action 2. Commissioner of Police, who is Shanu Bokshi, WBCS EXE, Inspector in charge, then authorized officer of the United Bank of India, then the borrower. So from this very document, it is absolutely clear that no copy of this order was served upon me. Let's take it further. It is argued by the learned counsel appearing for the applicant that the applicant was not served with the copy of the order of the learned DM, and accordingly the applicant could not challenge the purported order dated 20/2/2020. He has also argued that unless a person receives a copy of the order of the learned DM, the period of limitation would not run out. It appears that the learned...
Just a minute. The order of DM is dated 10th August 2020.
Yes, my lord.
But it says that purported order dated 20th February.
Now, kindly comes to page 121. This is the DM's order. I'll just show why is this the two dates. Page 121 is the DM's order.
Yes.
Let's see on the left-hand column, serial number and date of order is 20th February 2020. But the memo is dated, comes to page 123. The memo is dated 10th August 2020.
Okay.
The order passed in February. They wait for 6 months to issue a memo.
Okay.
Then, it appears that the learned DM passed the purported order dated 20/2/2020, copy of which was served upon the borrowers along with others as stated in the memo. So, the tribunal has taken cognizance that it was served on the borrowers along with others stated in the memo. So, when going through this, it was clear to the tribunal that the copy was not served upon me. It was clear. Then, the applicants, as it appears, are not the borrowers in respect of the loan. So they are aware. There's no provision in SARFAESI Act to serve copy of the order of the learned DM upon any third party. Naturally, copy of the order was not served upon the applicant. So the tribunal is aware it's not served upon me. Now, admittedly, the order of the DM was served upon the original borrowers who had mortgaged the property. It appears that applicants have filed a suit claiming as co-sharers being title suit number such and such before 7th Civil Judge Senior Division Nalipur, which is now pending for disposal. Claim of applicants as co-shares in subject matter of civil suit, but no decision has been arrived at the civil court. Well, may I pause here for a moment? This is a suit for partition, Mullah. Once a suit for partition is registered, it ipso facto shows that the parties to the suit are co-sharers. It is only at the preliminary stage or the final decree stage that the shares of the parties are determined and the property partition by myths and bounds. But the moment the partition suit is pending, it presupposes that the parties to the suit are co-sharers. So the tribunal is aware of this. It appears that the date of order of the learned DM is 2020, but this application has been filed on 14/11/2024 as it appears from the e-filing slip of the DRT. So the date of filing kindly marks it as 14/11/2024. And I received the copy of the order on 7/10/2024. Admitted, my lord. Now, my lord, it appears that the impugned order of the learned DM was passed on 2020. Instant application under section 17 was filed on 14/11/2024 beyond the prescribed statutory limitation. May I put it, my lord? The limitation is 45 days. Then, my lord, date of knowledge as stated in the application is not satisfactory. Because from the impugned order dated such and such passed by the learned DM, it appears that the copy of the order was also forwarded to the borrowers. What sort of reasoning is this, my lord? In one breath, the tribunal says we are not borrowers. In one breath, the tribunal says, yes, it was served on the persons mentioned in the memo, which does not bear my name. And then, my lord, the tribunal proceeds as if I was aware of the order at the time when it was filed and when it was passed. Then, my lord, there's no provision in law that the applicants alleged to be co-sharers expect to get service of copy of the order for DM. So he records this, that I'm not supposed to get, and I did not get. Then he goes on Section 5 of Limitation Act and says Section 5 of the Limitation Act is not applicable insofar as Section 17 is concerned. But I bow down to that, my lord. It's settled. But in my case, my Section 5 doesn't even arise. Then, my lord, the next page, my lord, sees it was incumbent on the part of the essay applicant to file essay within 45 days from the date of purported order of DM such and such, but the essay is filed much beyond 45 days from the date of DM order. I am afraid the instant application hopelessly bar limitation, hence order dismissed. So, my lord, kindly sees, my lord, what your lordship's court has held, my lord.
Hey, Dimnadu.
Lord, Deacon India Private Limited and others versus Canara Bank. Lord, and may I say this, Lord, I had the occasion to appeal to the tribunal, Lord. This judgment was cited, but there's no reflection of the judgment, Lord, in the order. And I say it with authority, Lord, I appeared in person. Kindly seize, Lord. The petitioners seek quashing of a certificate of sale dated 2nd August 2021 and the restraint on the respondent bank from acting in terms of the sale certificate. The petitioner number 1 is the borrower, respondent bank is the secured creditor. Look, here this was at the instance of a borrower. My case is on a far better footing. Look, kindly seize, Mullet. Then, Mullet, in the second paragraph, the respondent Canara Bank's objection, and Mullet kindly sees in the last 4 lines, there's a reference to a judgment passed by the Calcutta High Court in Akshat Commercial versus Kalpana Chakraborty, 2010, Calcutta 138. In support of the contention that Section 5 is not applicable. And I'm aware of the bow down, Mullet. Then Mullet kindly comes to paragraph number 6. This is important, Mullet. This is the ratio. Moreover, the time period mentioned in Section 17(1) of the SARFACI Act must be given a purposive construction. Although the starting point is the date of the impugned measure taken by the secured creditor, the provision would be rendered arbitrary and ineffective if the date of knowledge of the person under Section 17 is not taken into account. If the date of knowledge is discounted, then most applications under Section 17(1) would be rendered infructuous, particularly where the person receives the communication of the impugned order beyond the 45-day time limit. It is completely believable that the petitioners did not approach the DRT on the apprehension the petitioner's application would be kept out and might not be given a hearing. So, in this matter, the petitioners did not approach the DRT. Rather, it approached the High Court. Under the apprehension that in any event, since a period of 45 days had elapsed, the DRT would throw him out. But I also came before the High Court. The High Court granted me a liberty to move the DRT. Admittedly, the copy of the order is being served upon me for the first time on 7th of October. Admittedly, on 14th of November, I filed the SARFACI application within the 45 days. No, I fail to understand, my lord. After all this and after the judgment of this honorable court was placed before the tribunal, what prompted the tribunal to hold that I ought to have challenged the order from 45 days from 10/8/22? 2020, when I am not in receipt of a copy of the order, to levy a successful challenge, I should have a copy of the order. I should know what I'm against. If that is not there, then this court holds that this order is being served to me for the first time on 7th of October. And admittedly, I filed the application on 14th of November. But how could, if I may pose the question, if the question is myself, how could the tribunal throw me out on the ground of limitation? But these are my submissions so far as the mental limit is concerned. And I've been since the bank was waiting since this matter was pending with the tribunal. Now, since the tribunal dismissed it, the bank and the police is in hot haste. They have told me that tomorrow, the Saturday, the bank and the police will take possession because tomorrow is the working day for the bank. But I will be seeking a stay and or further progress of the TM's order.
Pending disciplinary order dated August.
Well, I've sought for a stay in my
Stay of the DM's order.
Yes, my lord.
So for a setting aside is that we are not concerned with that right now.
Not now, my lord. For the time being, I wanted a protection, limited protection from my lord.
So only on that ground itself, the application. Okay. Ashun.
The application would exist only on limitation, even without serving notice on the bank.
This civil revisional application under Article 227 of the Constitution of India has been filed, challenging the order dated 2nd December 2024 passed by the Date Recovery Tribunal -3 Kolkata, within bracket hereinafter referred to as the DRT. The fact of the petitioner's case in nutshell is that the petitioners are the co-sharers in respect of the property in question. And they are also residing in the property.
Yes.
They have been residing in the property.
Petition number 2 is carrying on business.
Petition number 1 is residing in the said property, and petition number 2 is carrying on the business in the said property under the name and style of Shakti Enterprise. And the ground floor of the said property is occupied by the tenants. In the month of July 2023, the petitioners came to learn from Dr. Anirban Mitro. He is also a co-sharer?
Yes, sir.
One of the co-sharers, that one Amropali Medical Center and Nursing Home Private Limited, of which he was a director, had availed of financial accommodation from the United Bank of India, bracketed presently Punjab National Bank. And they have mortgaged the property in question with the bank to secure repayment thereof. Where you have stated that particular account was made NPA by the bank and the borrower failed to repay, owing to, yes, it is there. Stop. Owing to default on the part of the said borrower to repay the said financial accommodation availed of, the bank resorted to mechanism envisaged under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, within bracket hereinafter in short SURFACE Act. And take over possession of the property in question. On 20th February 2020, the District Magistrate, 24 Parganas South, issued order for taking over possession of the property in question the copy of such order was forwarded to the parties V-Day memo dated 10th August 2020. The petitioner, where is that writ petition has been pleaded?
Kindly sees page 118 is the order passed in writ petition and
No. I have seen that order in the in your
10 para
pleadings.
14. Page 10 para 14.
The petitioner was constrained to approach this honorable court V-Day being WPA 25352 of 2024 for adequate redressal of his grievance.
Their grievance, two petitioners.
Their grievance. By order dated 7th October 2024, the writ petition was disposed of, granting liberty to the petitioners to approach the DRT under Section 17 of the SURFACE Act. And the issue of limitation was kept open to be decided by the DRT. Pursuant thereto, the petitioner filed an application under Section 17 of the SURFACE Act seeking for appropriate reliefs. When it was filed on 14 November.
14 November.
On 14 November 2024. And also sought for stay of the order of the district magistrate 24 Pargana South dated 20th February 2020. The application of the petitioner under Section 17 of the SURFACE Act was dismissed on the ground of being barred by limitation. What is the date of that order?
2nd of December 2024.
2nd December 2020. Being aggrieved and dissatisfied with the impugned order, this appeal court is not functioning right now?
This week is not functioning. I would have told that too. That's also been pleaded. Para 26.
Being aggrieved and dissatisfied with the impugned order of the DRT, the petitioner has preferred the present revisional application. Mr. Porijit Bordhan, learned advocate, appearing for the petitioners, submits that the copy of the order passed by the district magistrate 24 Pargana South was never served upon the petitioners. Therefore, the period of limitation of 45 days enshrined under Section 17(1) of the SURFACE Act will count from the date of knowledge and not from the date of the order. In support of his contention, he relies on the decision of this court passed in Deccan India Private Limited. Therefore, the order of dismissal by the DRT on the ground of the application under Section 17 being barred by limitation of the SURFACE Act, 17 of the SURFACE Act is not sustainable. He also informs the court that the bank has already taken measures for execution of the order for taking over possession of the property in question in the meantime. which would be executed shortly. He seeks for stay of the order passed by district magistrate dated 20th February 2020. On going through the impugned order under challenge of the DRT, it is found that the application under section 17 of the filed by the petitioners upon liberty being given by this honorable court in WPA number diye deben, was dismissed on the ground of limitation. The learned DRT has observed that according to section 17(1), the period of 45 days as mandated commence from date on which a measure under section 13(4) has been adopted. It is pertinent to note that the order of the district magistrate South Chobbish Pargana was never served upon the petitioners. Sorry, never, no, it is was only served upon the petitioner at the time of hearing of the writ petition on 7th October 2024, as recorded in the order. It has been recorded
And you see page
as recorded in the order.
120. One a copy of the order of dispatch has been handed over the advocate for the bank to the petition advocate record.
Okay.
Page 120, the first paragraph. Last few lines.
The order in Deccan India Private Limited, paragraph 6 টা quote করবেন। Is reproduced as hereunder, para 6. Bearing in mind the aforesaid observation, which records that if the date of knowledge is discounted, then most applications under section 17(1) would be rendered infructuous, particularly where the person inverted comma receives the communication of the impugned action beyond the 45-day time limit. The aforesaid observation squarely applies to the facts of this case, where it is found that the order of the district magistrate South Chobbish Pargana was served upon the petitioners on 7th October 2024. Such being the position, I find that this court finds that an arguable case has been made out. Accordingly, there will be stay of order dated 20th February 2020 passed by District Magistrate South 24 Parganas in, where is that order?
That order is at page 121. 121.
20th February 2020 under memo number 10th August 2020 for a period of 6 weeks or until further orders, whichever is earlier. Petitioners are directed to serve copy of this application. Caveat আছে নাকি? No? No notice of caveat has been served. Copy of this application upon the respondents and file affidavit of service on the returnable date at 6 weeks or until further as বললো না 6 weeks হলে কবে আসবে 6 weeks হলে কবে আসবে জানুয়ারি মাস একটু এগিয়ে দেবো 17 January. List this matter after 1 week of the winter vacation. It will appear after 1 week and the stay is for 6 weeks.
I'm so grateful, so grateful.
As a party shall be at liberty to pay for extension modification যেটা থাকে
One indictment could this order be uploaded?
today it will be uploaded.
I'm so grateful, so grateful. I'm sorry for bothering you.
No case.
Weekend. I'm so grateful.
Supplementary list, item number 1.
My application. Well, this is the affidavit of service. And this is the order passed on the last petition by Honorable Justice on 11 July 2024.
Affidavit of service filed on behalf of it will be taken on record. Sir. This is appearing in the list of which court?
Initially before the Honorable Justice Vishwas Basu and thereafter, my lord, it is before the Rajavasu Chaudhuri. And as his lordship is not sitting, my lord, it was mentioned yesterday, and his lordship was fixed to today, my lord. Court number 22.
It is appearing before Justice.
Today. Item number 2.
So and so, learned advocate for the petitioner seeks for extension of the order, interim order granted earlier on 11 July 2020. And the interim order be extended for a period of 6 weeks or until further order, whichever is earlier, list this matter in the combined monthly list of common purchases and date the other one. January. For a period of 6 weeks and combined monthly list of January, this will appear.
I'm grateful, my lord. But the order will be uploaded, my lord, by today, my lord. I upload grateful, my lord.
চলো আমাদের লিস্টে
Daily list, item number 8.
Item number 8, my lord, I am for the petitioner. My lord would find from the previous orders that on visited occasions time has been sought.
Since circumstances the affidavit also ready, where is your opposition? Give a copy to affidavit in opposition filed on behalf of state respondent is taken on record. Copy.
Yes, my lord, copy has been
Copy,
served.
sir. In filing any reply,
I have to go through. Just now they have handed over this.
Mr. So and so, learned advocate for the petitioner, seeks to file affidavit in reply to the affidavit in reply to the affidavit in opposition filed by the state respondent.
20th December, if my lord fixes within that time, I will file my exception and serve him at
Not exception, this will be reply.
Yes, my lord, reply.
Let such affidavit in reply be filed within a period of 3 weeks হবে না 3 weeks হলে কবে যাবে শেষের দিকে নিয়ে ওটাকে তারপরে ওখানে ফিক্স করে দেবে না ও 20 তারিখের মধ্যে আমি ভ্যাকেশনে ফার্স্ট উইকে দিয়ে দিলাম reply be filed within 1 week of reopening. Within 1 week of reopening, list this matter after 1 week. 1 week after one winter vacation. এটা দাও না গো লিস্টটা
Item number 9.
So why you are not appearing? You are appearing for the state. So you are giving pain to Mr. Lady to serve notice and then he will come.
Also gives us pain. I can't say anything about.
Copy has been given.
No,
Yes.
my lord, I'll
Copy
take.
this. Correct this. I'm giving another.
A report in the form of affidavit filed by his respond number. Land manager is respond number.
I'm taking.
Filed by the land manager.
Respond number 3.
Respond number 3 is taken on record. Copy served. Mr. Anindul ID, learned senior advocate, appearing for the petitioner, seeks to file reply. Let such within Mr. Lady.
Yes. 1 week or 2 weeks, sir.
After the vacation?
Yes.
Mr. Let such affidavit in reply be filed 1 week after the winter vacation. Please this matter after 1 week. Oh, exception. Sorry, reply no exception. Sorry. Exception.
Exception.
Item number 10.
Mr. Lady, congratulations.
No, it is the lordships graces that the lordships have been, entire full court has been pleased to.
Item 10, I am for the petitioner. Lordship, this is the matter wherein by last order dated 21st of November, your Lordship was pleased to allow the substitution application. And the matter
21st
November.
21st November, it was adjourned.
Yes, Lordship had allowed the substitution application and
When?
directed the department to incorporate the applicant's name.
When was the substitution application allowed?
On 20. Lordship, the last order is 21st of November.
21st of November is a matter adjourned. There is no order passed for substitution. Which matter are you moving?
Lordship, item number 10. That is 3049 of 2014. 30849.
308 এই এটা ভুল দিয়েছো না 11 নম্বর দিয়েছো
ওটা চলে এসেছে
Lordship, in the days list, the petitioner's name is appearing instead of the name of the substituted applicant. Lordship, the advocate on record is not present today. I am praying that the matter, Lordship had directed to.
Wait. কি হয়েছে ভাই ডিপার্টমেন্ট কেন করেনি এটা দেখো সেটা করেছেই তো অ্যাড করেছে তো তো ওই এটা কজ টাইটেলটা পাল্টাতে হবে মনে হচ্ছে কজ টাইটেল হ্যাজ টু বি চেঞ্জড ও বিমল হালদার তো ওই তো ডিসিজড কজ টাইটেলটা পাল্টাতে হবে এটা লিস্টিং এ একটু নোট করে নেবে
Lordship had given us the liberty to mention the matter. Lordship, we have not mentioned the matter. The matter is appearing on its own motion. But if the advocate on record is not present, if the matter be listed after vacation, Lordship, in the meantime, the necessary incorporation can be carried out.
Incorporation has already been made by the department. Now, inadvertently, the name of the previous petitioner is appearing who has died. এটা নোট করে নাও হ্যাঁ চেঞ্জ হয়ে যাবে Here is the report of the Assistant Registrar 8 dated 5th December 2024. It is found from the aforesaid report that necessary incorporation has been made pursuant to the order of this court passed on 21st November 2024. On the prayer of learned advocate for the petitioner. Achha, none appears for the state respondents. Release this matter 2 weeks after the winter vacation. ওটা কি কিছু রেকর্ড করতে হবে অর্ডারে না আপনারা করে দেবেন? The petitioner that the name of Bimal Haldar should be deleted from the cause title and the name of the substituted legal years
Kusum Haldar.
be
Kusum Haldar and
Kusum Lata,
no, Kusum Haldar.
Kusum Haldar and others be mentioned in the list. কি করে register department is directed to make necessary correction in the list. Making necessary changes in the বলে কি বলে ওয়েবসাইট কিসে করে বলে তো
1 week. 2 weeks after vacation. Item number 11.
In this matter, we have
what is this matter? Who is for the state? Tanushri Mukherjee.
state respondents are not appearing today, my lord.
Oh.
Lordship may allow a passover and take it up at 2 p.m.
দু সপ্তাহ পরে winter vacation 2 সপ্তাহ পরে on the prayer of none appears on behalf of the state on the prayer of learned advocate for the petitioner release this matter 2 weeks after the meeting.
Item number 12. For the petitioner, my lord, in this matter, my lord.
Related type of matter will have been fixed by laws for 19 PHE matter.
Earlier occasion, they wait for accommodation to file opposition.
Where is your affidavit?
The affidavit has been served, my junior state lord has been served. It is not served, lord. On Monday I will serve, lord. It has been affirmed. It has been affirmed. I personally was there, lord, when it is been affirmed.
On Monday you will file that?
Monday will.
Not today then?
I will.
On Monday.
The bunch of matters are there, lord, all to be heard today.
Yeah.
Item number 13. Similar, my lord.
Filing the affidavit in opposition.
File affidavit in opposition. Fine. On behalf of the state, respondent is taken on record. Reply.
Not filing any reply, my lord.
Mr. Swenso, learned advocate appearing for the petitioner, submits that his client shall not file any affidavit in reply. This is 19th.
Yes, my lord. Others matter.
This matter on 19th.
Super, my lord.
Copy. You have given copy?
Copy, please. Copy, correct. Item number 14. Sir. This is also, my lord, the same, my lord. Little bit of
neither the state is represented nor any affidavit in opposition is filed. It is informed by the learned advocate for the petitioner that the related matters dealing in similar issue is scheduled to appear on 19th December 2024. Accordingly, list this matter on 19th.
Item number 15.
Copy here. A report in the form of affidavit filed by the state respondent is taken on record. Copy served. Any reply or exception to the report? Similar submissions, huh? Is this matter on 19th? This is same. Right.
Item number 16.
Sir, this is the second round of litigation. Initially, a writ petition was moved before Honorable Justice Rajashekhar Mantha, and thereafter their lordship has been pleased to direct to consider the representation to the Special Land Acquisition Officer for payment of compensation, my lord. Thereafter, the Special Land Reforms Officer has conducted a hearing after calling upon all the writ petitioners. Thereafter, it has been held by the Special Land Acquisition Officer that the writ petitioners are entitled to get compensation. But, my lord, in that order, no specific time has been given by which time that compensation has to be paid. That basis, my lord, this writ petition has been filed. My lord, in their affidavit in reply, they are agreeable. It has been admitted by them that they are agreeable to pay the compensation according to the direct purchase policy, and they are agreeable to get compensation according to the direct purchase policy.
Where it is allowed. Who is the petitioner?
Petitioner. There are number of petitioners. There are 12 petitioners. The order.
Sudarshan.
Sudarshan, my lord.
Take Sudarshan.
Page number 37, my lord. Page number 37.
Hence is entitled. Payment of two entitled. What is his name? Birinchi. Birinchi. ঠিক আছে বিরিঞ্চি পাবে
Fourth paragraph, my lord. There has been
সমীর সমীর আর দিবাকর
Umid is on page number 38, madam. Thereafter, my lord, 3 and 4, Shomir and Dibakar. Thereafter, 5 is Kauribala.
Same right title. What is the finding with regard to Somir?
From their share has been utilized the plot number 190, and they are entitled for compensation with it.
Entitled.
My lord, 2 paragraphs.
Dibakar is not a petitioner?
So, Dibakar is also a petitioner.
Dibakar is a petitioner?
Yes, my lord.
Number?
Dibakar was deceased and his son has been entered appearance. That is page petition
4.
number 4.
Achha.
4.
5 is?
5 is
Gauri.
Gauribala.
Fail to compensate. 6 and 7.
6, 7.
Joydev and Mahadev.
Joydev is page number 39.
Not today, go. Monday to go. Monday. Not.
Next matter. That matter where I was arguing on behalf of the private respondent at it later.
IOC.
My lord, next week, my lord, we all were waiting if we can conclude my argument. My lord, next week, Monday, Tuesday, I have some difficulty, professional reason.
When can it be done? You? When?
It is subject to my lord's convenience. My lord, may you please to recall that I was in the midst of my argument. If any time, I'll take around 20-25 minutes.
They will also have to reply. Mr. Banerjee is.
Then Mr. Banerjee learned senior counsel, he will reply.
Yours is complete.
I otherwise complete document which is that
কবে দেবো 18th petition
18th মানে any time subject to that commensurate to my notes convenience. 12:30 or 12.
এরকম হয় নাকি মিস্টার মুখার্জি 12:30 then you have to wait for half an hour then you will say that sir you have given 12:30 then why have you made me waiting for 30
No, I did not say. Certainly, I will not say. I know the business of the honorable court. Sometimes
18th আমরা তো Wednesday second half Wednesday second half 2 p.m. টপে থাকছে এটা you conclude this side because they will be given time in the other side of the vacation to reply.
we can come back to the other side of the vacation because after my reply is concluded, Mr. Banerjee will certainly give his reply and will be troubling your lordship.
Let it be on 18th, huh? Let it be on 18th. If you could complete then. Huh?
In unavoidable, sir. But in a formal order,
My lord, in unavoidable circumstances, I have mentioned before your lordship, the matter is enlisted in this list, but there is 9th, there is order passed in the trial court. Lordship kindly.
No, I cannot take it like this. I have original side matters after this. I have done. In the morning, if you had mentioned, I would have made a supplementary list and taken it. Record has to come, then I have to pass order. No, it is not possible right now. You could have mentioned in the early morning. I would have taken. Yes, Mr. Mukherjee.
Formal order may pass my
Formal order will be required.
My lord, all three of us. My lord, I understand. A one-liner.
9th order
I was
passed by
still
the
is
trial
also
court,
there.
preliminary degree passed by. That's why the lordship already extension order already passed. Lordship, if this after original side it take only just 1 minute, lordship. Extension
No matter of 1 minute. Huh? Is that you? No, হবে না। The order না দিলে আসবে না। কোনোদিন এক লাইন order দিই। On the prayer of the learned advocates for representing the respective parties, is the matter on 18th.
Yes. I'll conclude on that. Great. Sorry.
Any mentioning in regular bench? Daily list item number 1.
Lordship has appointed Miller. Lord, the petitioner is absent. Mr. Mitra had moved this application. We had contested. Extremely grateful.
Item number 2.
But the thing that I wanted to say is that I have had a word with my editor on record. When he was and I was, but I'm proceeding to the I was just yesterday in the evening while sitting in the chamber, I was just thinking, my fate, had it been in some other honorable judge or in the past. Only request is, Milord, since the time has lapsed, and if your lordship would be allowing my attachment's application, hereby will be required to serve the writ of summons upon the added defendant. One of the heir is not there in the array of defendants. So that defendant will be allowed to, the added defendant will be allowed to refile the written statement if that
if permissible in law. If permissible in law, because none of the defendants have filed their written statement in the suit. But if it is permissible in law, then the added defendants will file. If it is not, lordship will not make any observation to that.
Is my under the order or my defendant placed. The time to file the written statement had expired on 30th November 2019. For 5 long years, Milord, he has not taken any steps for the suit being heard as an independent. But after 3-4 weeks,
That I'm objecting. That I'm objecting.
That's my humble prayer.
That I'm objecting.
I leave it up to you.
GA5, I'm sorry. GA6 is the application for dismissal of my suit. Yes, but GA5 is my application. Yes. For substitution of different number 4.
से आगे करूँ ना. This is an application for rejection of plaint.
Because that I'm not really pressing.
After all this, my learned
I say so is, my lord.
After being caught,
My lordship remembers my yesterday's argument. Did not make any averment in the opposition that this was just even he did never knew about this order.
Is that a ground? The existence of the order was recorded in the letter. My learned senior friend should have shown that. I was waiting for my learned senior friend to show that order.
He was not even aware.
No, no, no. That is not a ground.
Let's record all the aspects that has gone down at the time of
Kindly do that.
Column?
For rejection of claim.
Rejection of claim. The principal contention of the petitioner is that since the filing of the suit, no writ of summons were lodged to serve upon the defendant. As per Rule 6 of it, origin say Rule 6 of the Chapter 8. Mr. Mohit Gupta, learned advocate for the applicant, submits that the plaintiff did not take any steps for lodging of writ of summons. And there was no order of the court extending the time to file writ of summons. Accordingly, in view of Order 7, Rule 11, Sub-Rule F of the Civil Procedure Code, the suit is liable to be dismissed. Mr. Saurojit Dasgupta, learned advocate for the plaintiff respondent, on the contrary, submits that by order dated, the copy chilo order, by order dated, আচ্ছা ওনার না মিস্টার গুপ্তর সাবমিশনে এইটা নিয়ে নিন, এই যে শ্রীকান্ত মিত্র হি টু বাট্রেস হিজ কন্টেনশন হি রিলাইজ অন শ্রীকান্ত মন্ত্রী, এটা submits that by order dated 28th August 2019, the writ of summons, the service of writ of summons of the suit on the defendants was dispensed with, and the defendants were directed to file their respective written statement within 30th November 2019. Therefore, the ground raised by the applicant is not at all sustainable. He also indicates that the order dated 28th August 2019 was duly served upon the learned advocate on record for the applicant defendant. However, the said fact has not been disclosed before the court. He seeks for dismissal of the application as well as for appropriate orders. Mr. Gupta, learned advocate for the applicant at this stage, seeks unconditional apology for not bringing it to the notice of the court. Well, by order dated 28th August 2019, following directions were issued in view of since ওটা পরে কোট করার পরে এই পুরো এটা since by such order the service of writ of summons was dispensed with, therefore the ground taken in the present application falls short of merit. Accordingly, the application being GA 5 of 26, 6 of 2024 stands dismissed. The applicant, including the other defendants, were directed to file the written statement within a period of 30th November 2019. It is informed by the learned advocate that the defendant applicant has not filed their written statement since passing of the order on 20th August 2019 till 30th November 2019. Such being the position, the suit will proceed undefended against the applicant defendant. 5 GA 5 of 2024, this is an application for substitution of which?
Defendant number 4, and it takes for page 13.
Substitution of legal years of defendant number 4.
4. And 4A would be impleted. Page 14, that is the proposed amendment.
No, in the application, which paragraph?
Page 5, paragraph 4.
4. Mr. Sorojit, this is an application substitution. Das Gupta, learned advocate for the petitioner, submits that during the pendency of the suit, defendant number 4, Srimati Sumitra Devi Chaudhary, has expired. And as such, her death is required to be recorded and her name be expunged. The said Sumitra Devi Chaudhary left behind 3 sons and 1 daughter. The sons are already on record as defendant number 1, 2, and 3. And only the daughter Sweetie Chaudhary is to be added as defendant number 4.
But instead of 3 sons, there will be 2 sons. 2 sons, 1 daughter. And there was the husband is there.
Husband?
Husband is the defendant number 1. 2 and 3 are the sons.
As regards defendant number, his claim that defendant number 2 is the son of defendant number 4, that bit I am disputing because the issue is that one of the brothers of defendant number 1 had adopted defendant number 2.
Yes. So that adoption has not been set aside, has not been declared as null and void. He still stands as a son.
Otherwise, my learned
It is only my contention that your lordship is recording. That there are 2 sons who are on record, and there is the daughter.
Sons are already on record. Husband has died.
No, husband is alive. My learned senior is
Oh, acha. So 2 sons, husband, 2 sons and 1 daughter. He seeks for substitution, which is more fully described in paragraph number 4 of the application. He seeks for substitution of the daughter, namely Sweetie Chaudhary, as defendant number 4A. A. Where is the death certificate?
The death certificate I don't have.
But they had no knowledge.
But I don't have the death certificate. But that part is admitted. That there is no dispute.
Okay. In view of the amendments made in the application, let there be order in terms of prayer A to F of the master summons. Department is directed to carry out the amendments within a period of 2 weeks or হবে না within a period of 4 weeks from date of service, date of communication of the order. GA5 or 2024, chance disposed of.
But just one, since my lord has recorded his contention that defendant number 2 is the son of defendant number 4. Will kindly also record that I am disputing this petition.
Mr. Mohit Gupta, learned advocate for the petitioner, disputes.
Defendant number 1.
Defendant number 1, yes. Disputes that defendant number 2 is the son of the deceased defendant number 4. You know,
Just renew the prayer once.
which one?
Filing written statement. That for filing written statement. But in GS6, towards the end, Lordship has recorded the suit will proceed undefended as against the defendant number 1. Will it be a Lordship's pleasure to record against all the defendants because none of them have filed, and upon all
Against
the amended
all the defendants, including defendant number 1.
That would also, I mean, I am not sure whether that would preclude if the new added defendant.
That is, if it is permissible in law, 4A will be filing a written statement if well instructed. I see to it whenever that written statement comes, we'll see.
The 4A is not on record right now.
Yes.
This order.
Witness action item number 4.
My lord, I beg to appear for defendant number 3 online, my lord, due to my medical emergency disease. My lord, I appear for the defendant number 3, my lord. Only prayer I am making, my lord.
The evidence has been concluded. Now it is for the bank, who is defendant number 3, to adduce evidence, and Lordship had directed by the last order to be present today.
My lord, may I submit, my lord? May I submit, my lord? Am I audible, my lord?
Yes.
My lord, what happened in this matter, my lord? I have communicated the order. There has been some emails exchanged between me and the bank. My lord, only difficulty is, my lord, this is the case of 1997, and suit was transferred to this honorable court in 2007. My lord, the bank had intimated that they were unable to trace the documents, as also the credible the bank officers who can give evidence before your lordship. Of late, my lord, yesterday, my lord, the bank has intimated, my lord, the branch head will give evidence, my lord. But they are asking for more time, which I am not in favor of. But if your lordship, considering everything, my lord, if your lordship can fix any accommodate us, my lord, the bank in any day in the next month, my lord, that's the only prayer, my lord. I will not stand in. They are asking for more time. But I cannot make such submissions before your lordship. That is the only difficulty, my lord.
Where is that letter?
My lord, the letter is there, my lord. Kindly, my lord. There are first letter, my lord. My junior is there, my lord. 13/11/2024. My lord, 13/11/2024 is the first letter, my lord. the bank had issued, though it was addressed to me, that's an instruction, my lord, to the council, my lord. Now, last paragraph, my lord, the time I'm not, I cannot make such submission.
Second week of January to देखो. Second week of January.
No, let it be a court's order, my lord. I shall communicate to the bank as a last chance also, my lord. I will not stand in the, but only thing, my lord, kindly make it a court's order, my lord. Otherwise,
Mr.
Manoj,
Learned advocate appearing for defendant number 3, Bank of Baroda, seeks submits that since the suit is old one, the documents pertaining to the suit, the bank is unable to trace out the relevant papers and documents pertaining to the suit.
no, my lord, we have now retrieved some documents, my lord.
He also indicates that some of the documents have been retrieved.
It was located, my lord.
He seeks accommodation in the month of January 2025. List this matter 15 January for approval. 17th January 2025 for examination of, I don't know what is the date, Wednesday? Friday, 2 p.m. For examination of witness on behalf of defendant number 3, Bank of Baroda.
My lord, may I make a humble prayer, my lord? Your lordship has recorded that I seek time, my lord, the bank seeks times, my lord. Otherwise, my lord, I will be, they are asking for.
He seeks accommodation on behalf of the bank, will be correct?
My lord, yes, my lord, correct. Absolutely correct. I'm so sorry.
Let it be preemptively, my lord. Preemptively, my lord.
The direction as aforesaid is made peremptory.
Yes, ma'am. Deeply obliged, ma'am. Deeply obliged.
Take this letter. A letter at the end.
Item number 5.
I'm for the plaintiff.
I took an adjournment on the ground that the defendants it was really my witness action or the defendant's witness which was supposed to be there in the box. On the last occasion, I had taken an adjournment. I had prayed because the defendant had a heart ailment and was undergone a surgery, and hence I had prayed for some time, and had also indicated that I am going to file a special leave petition from the last order passed. But I'll tell you, Lordship, very briefly, a suit for delivery up and cancellation of several deeds in respect of 4 properties. Out of the 4 properties, 3 of such properties are admittedly outside the jurisdiction of this honorable court. They have sought for leave under clause 12 of the latest patent on the ground that one of the property is within and hence cause of action is within. But we contended that the 4 properties have separate causes of action, separate deeds were executed, and those separate deeds were in respect of properties which were admittedly outside the jurisdiction. So this point we had taken in an application for revocation of leave granted under clause 12. That application was initially disposed of, and thereafter we preferred an appeal, rejected, preferred an appeal. In the appeal, it is directed that it has to be taken as a preliminary point. But despite that, the honorable division bench of this honorable court had directed that the witness action should be completed of the entire suit prior to deciding this preliminary issue. On that limited point, we indicated before your lordship on the last occasion, apart from the ailment portion, that we need to file a special leave petition only limited to that extent. We have done that. We have received the diary number. It's 57062 of 2024. 57062 of 2024. That's the diary number we have received. we have filed the special leave petition only to the limited extent that the witness action of the entire suit. The parties are embroiled in this litigation. Why when the preliminary the jurisdictional point has to be decided first, that has been decided by the honorable decision bench. Why go through the rigorous process of the entire trial of the suit, which really does not entail to any party's benefit. So which is why we have filed a special leave petition only to that limited extent. And other than that also my client is in Bombay. He's also not well. If at all this nothing happens is in the special leave petition, we would have to perhaps come back with your lordship with an application for doing the witness action on commission. Those are my respectful submissions. So as on the last occasion.
If lordship records the lordship in the last order of 11th November 2024, where I recorded the operative part of the order of the Honorable Appeal Court, the second page of the order. There, if my land's contention is that the Appeal Court said that the jurisdictional issue has to be decided first. Now, lordship has recorded the operative part of the order. There nowhere it has been said that the jurisdiction issue will be decided first. The order says that, in effect, the trial will take place. After the trial, the jurisdiction issue with all other issues will be there. The court will obviously adjudicate the issues. The first issue will be jurisdictional issue. After completion of the trial, if that succeeds, then the suit will be dismissed naturally. If that fails, then obviously suit will be decreed in terms of the other issues. That's the effect of the order of the Appeal Court. Today I am informed that they have filed from them I am being informed. Irrespective of that, there is no stay order of stay.
That's fine.
And the Appeal Court directed, the requested the trial court to proceed with and conclude the trial expeditiously. That in November. In terms of that, the matter was fixed today. My instruction is that the heart surgery that they mentioned had happened 6 months back. It was a stained operation. I'm not commenting on that. Lordship on the last occasion gave them a chance. Today again, another chance is being sought. Kindly, because I am the plaintiff stuck here, from 2008. 2008 suit, my witness action is complete long back. It's been 1.5 years. For this one witness action. If this witness is not capable, then some other witness come.
I'll tell you, lordship,
some other witness may come and give evidence.
No, that will not happen. Of course, the person who knows the suit has to come. I
can't come, then somebody else will come.
Now, the difficulty is that the Honorable Supreme Court will close down from 15th of December and or reopen sometime in the middle of January. So, I was humbly beseeching your lordship, if your lordship kindly keeps it sometime in the end of January, we can come to a final conclusion. And whatever happens, either we come back with an application for doing the witness action on commission, or I submit to your lordship jurisdiction.
Kindly make it peremptory at this time.
I'm not asking.
Last time I request lordship said no, one chance should be given. This time here I'm saying kindly otherwise
so what will happen
continue
if they succeed before the
this is the diary only. SLP number is not even there. Let them move it. Let us say 2 courts have rejected their prayer. So there's a matter of right, they have gone there, but admission is not matter of right.
Mr. Shankar Sarkar, London advocate for defendant number 1A to 3C, submits that his clients have preferred a special leave petition, SLP, diary number.
I'm telling you, lordship. It's diary number 57062 of 2024.
57062 of 2024. Challenging the order passed in APO 39 of 2024. He also informs the court that the matter is matter will be taken up after the winter vacation of the Honorable Supreme Court. He seeks the matter will be fixed after in the last week of January 2025. Please, this matter, শেষের দিকে document. 27th.
I'm grateful.
Grateful. Kindly direct them to this time at least a prior
uh,
intimation, something
just
should be
only
arranged.
one sentence.
If
If your
not well,
lordship,
we can come back with commission.
if your lordship kindly also records that he is also today in Bombay with ailment, which is why
He also informs the court that the witness, Mr. What is his Ashok Kumar Kharkaria, Kharkia, defendant number 2, is presently at Mumbai for treatment.
Yes.
For treatment of his heart ailment. 27 January.
Kindly make it some direction upon them.
Next, you will see. Next.
Grateful.
New motion item number 6.
I beg to appear for the applicant, my lord. May I just indicate, my lord, that this application is carried out by me, my lord, for handing over the Pala Puja from one Sevaiyat group to another Sevaiyat group, my lord. The Sevaiyat order passed by this honorable court, my lord. May I, my lord, placed the order, my lord. Earlier occasion passed in this regard, my lord. For your lordship, my lord, better. No, regarding prayer, but change over the Pala Mala, I think they are not opposing, my lord. May I just indicate the case, my lord, then lordship can adjourn the matter, my lord. Now, my lord, kindly turn to page 20A. My lord, the first order passed by the Honorable Justice Rumapal was then, my lord. And consider page 20A, the type copy of the order.
20A.
20A.
And this application is to on receiver in respect of a Devatara. Devatara state was created by Arpan Nama.
This is the first order passed in connection to this suit, my lord. Receiver has been appointed. Respect of this estate property, my lord. Subsequently, my lord, kindly turn to page, my lord, 22A. The subsequent order, my lord.
No, this is the continuation of that one.
This is the continuation, my lord. 21 is the, my lord, the conclusion of the order, my lord. Page 21A. It starts from, my lord, 20A.
Receiver will be.
First, my lord, joint receiver has been appointed, my lord. Subsequently, my lord, single receiver has been appointed.
Yes.
Kindly turn to page 22A. Order passed by Honorable Justice Barin Ghosh, my lord, Justice was then. The single receiver has been appointed, my lord, in respect of the, my lord, the Devatara estates. Lastly, on, my lord, I'm taking a lordship to, my lord, the page 24. The order dated 13th April 2021. Passed by the coordinate bench of your lordship, my lord. Honorable Justice Boshak, my lord, please to appoint, my lord, two joint receiver. The advocate and record of the both the side has been appointed receiver of this Devatara estates, my lord.
Both the sides means?
No, both the side, both the advocate and record, my lord. Plaintiff and defendant. And he turn to page 25, my lord, it's recorded, my lord. Now, my lord, the handing over the Pala is due on, my lord, 15th of this month. Each year, my lord, 1 year of it, my lord. Now it is due on 15th of this month, my lord. So that's why, my lord, I have carried out this application, my lord. I have other squares also. This one, the Sevaiyat last Sevaiyat has all passed away, my lord. The last Sevaiyat also passed away. So kindly turn to, my lord, page 25 Annexure P3, the death certificate of last Sebaid Malad.
Who are the receivers?
Both they are the
My lord, I am
receivers.
appearing for the receiver. My lord, he is another joint receiver. My lord, I'll indicate one thing. My lord, each year, my lord, the Pala my lord changed place from the Ghosh family to the Bosch family, or my lord, the elsewise. Last time it was the Pala of the Ghosh family. Mr. Bhoben Kumar Ghosh was the last Shebayat, your lordship. Now, my lord, Nishit Bose was the Shebayat of the Bose family. My lord, he passed away, my lord, and my learned senior, my lord, has shown me the death certificate. Now, thereafter, my lord, the elder son of the family is Mr. Shomen Bose, who is the applicant herein, my lord. Pala is to be handed over to him on 15th of December of each succeeding years. My lord, the Pala is to be handed over. We being the receiver, my lord, has to go there and my lord, they hand over the Pala to him. My lord, if order be passed declaring him as the Shebayat, my lord, we'll go and hand over the Pala to him.
Respect of the rest of the players, Malad, if they want Malad, file any opposition, I have no objection.
Just gain 15 in the Pala, hand over the Pala.
얘기는 또. 펜텐로. None. Order.
Item number 7.
That compromise, Lord, today I think Lordship can pass the order. Lord, for your
record to the
to give the background, my lord kindly is below at page 107, and this is a trust which was originally with the official trustee. My lord, official trustee was not looking after the properties and my lord, the trust. The purpose of the trust was getting frustrated. The sole Sebaid and the trustee, Lord Shambhunath Ghosh, Lord, he applied before this honorable court seeking permission because that is the only property that was remaining with the trust for the purpose of developing that, for maintaining the purpose of the trust. My lord, there was a direction for even before that, my lord, one of the developer, my lord Carewell, the existing trustee entered into an agreement because he didn't have the fund. That was placed before the court. Still, the honorable court was pleased to direct for making publications in the newspaper if better offer comes. My lord, that those publications are in page 107 and 108.
Yes.
After those publications, my lord kindly sees my lord at page 109, annexure D. My lord, by this order, my lord, the official trustee expressed its inability, my lord, to carry out the trust, and my lord it was directed, my lord, to hand over all the documents, and it was complied. So, my lord, official trustee, my lord, since then, my lord, the entire trust management, my lord, vested with the sole trustee, my lord, who is the applicant before your lordship. But this is the order dated 9th November 2005. My lord has been pleased to get that.
Yes.
The last paragraph, the official trustee who has been discharged by the previous order. My lord, it is recorded there. Discharged by the previous order, directed to hand over all the papers and the books of accounts, if not done already. My lord, it was done.
Page number?
My lord, 109. The last paragraph.
Yes.
Then, my lord, the next order, my lord, the next page, my lord, this is order dated 10th July 2006, passed by Honorable Justice Aniruddha Bose. My lord kindly sees, my lord, there, my lord, the direction for my lord, so for my lord, the development agreement is concerned, was given. My lord, the ratio was, if your lordship kindly sees, my lord, second paragraph from the last, my lord, was 30% and 70%. My lord, this is at page 111.
Yes.
Second paragraph from the last, my lord. Mr. Mollik, my lord, Carewell Properties was the highest offer.
Yes.
And my lord, direction was there, my lord, for taking step by the developer before the my lord Howrah Municipal Corporation for the purpose of sanction of plan. But the documents were not there. My lord, he tried to proceed. My lord, he procured the documents. In the meantime, my lord, there were certain disputes. My lord, cropped up. My lord, I placed that before your lordship, my lord, because of which, my lord, standard construction came into the picture. My lord, that is pursuant to order dated 23rd August 2006 at page 130. My lord, standard construction came into picture, and my lord, Carewell was, my lord, it was observed, my lord, that the contract with the Carewell was terminated.
Where? Which page?
My lord, page 113.
No, 113 does not say that.
Oh, no, my lord, I'm sorry, my lord, not 130. 116. 116. I'm sorry, my lord. Right. Now, standard construction, later notice. 2nd September. Then, my lord, 9th September. My lord, page 117. Yes. The next page, 10 lakhs should be furnished to Carewell. So, my lord, Carewell was ousted, and my lord, here, the important factor why I am bringing to your lordship's notice, my lord, the ratio was settled as 60:40. So, my lord, there was an enhancement and standard came into picture. Now, my lord, these, my lord, Carewell sought for a, my lord, recall of the order. My lord, that was allowed, my lord, pursuant to the order dated, my lord, at page 119. My lord, kindly sees, my lord. $124. My lord, kindly comes to my lord, 124. 124.
Yes.
My lord, that was the application by Carewell. By this application, the petitioner seeks recall of orders dated 2nd September, 9th September, and 16th September. 3 diverse order by which, my lord, the standard came into picture, and my lord, we were ousted. Now, my lord, this was recalled at the end. If your lordship kindly sees, my lord,
The
it is
earlier orders.
Yes.
This Carewell, the development agreement between the Carewell and the official trustee was not brought to the notice.
Not official trustee. Carewell and my lord, the sole Sebite and the trustee, because
Okay.
official trustee was discharged.
Trustee.
Only the formality was remaining of
Now,
handing over the papers.
Yes. This was not brought to the notice of the court.
This was brought to the notice of the court, and it was pointed out that, my lord, that Carewell failed to perform because this long pending, my lord, time that has passed by, and that's why it was the contention of Shambhunath Ghosh that, my lord, that contract was terminated. And on that premise, my lord, those 3 orders were passed. It was ultimately recalled by this order. The last page, my lord, last few lines of the last paragraph, my lord, at page 125. It is only for this reason that the orders dated 2nd September 2013, 9th September 2013, and 16th September 2013 cannot be sustained. My lord has been pleased to find that. So, my lord, it was recalled. Then, my lord, a review petition was filed by standard. Even that was, my lord, that is appearing at page 128. My lord, even that was turned up. Now, my lord, this is, my lord, so far, my lord, ATA 4, and my lord, these applications were disposed of. ATA 4 was remaining pending. At this stage, my lord, Carewell, my lord, filed a suit. My lord, in that suit, this ATA is still pending. My lord, that was meant for, my lord, specific performance of the contract. My lord, that was, my lord, existing between Carewell and the sole trust. Now, my lord, there, my lord, out of the court settlement was reached between the parties. Now, my lord, it could not be there because, my lord, originally, my lord, the litigation was before this honorable court. All the trust-related matter, my lord, that we are seeking to, my lord, enter into, my lord, is before this honorable court. The permissions were granted by this honorable. That's why, my lord, we took out this application. Now, my lord, lordship may kindly recollect, my lord, the depositions are there. My lord, so far, my lord, the agreement is concerned. My lord, there is a, my lord, kindly takes this.
So what is ATA 7 of 13?
ATA 7 of 13 was, my lord, our application separately.
Oh, application.
Yeah. Was it ATA 7?
And ATA 4 of 2003?
This is, my lord, the matter, my lord, we are appearing today before your lordship. This was by Shambhunath Ghosh, the original trustee.
What was the prayer in the suit?
My lord, for the purpose of, my lord, seeking, my lord, permission for entering into development of the trust property for development of that. Relating to which, my lord, we had to file a separate application that was numbered as ATA 4.
Okay. Yes.
My lord, am I clear to your lordship? Now, my lord, lordship kindly takes up this, my lord, this list of exhibits. Now, so far the depositions the parties have made, my lord, it has been settled. My lord, kindly sees, my lord, exhibit F, my lord, that is part of your lordship's annexure I.
Hmm.
My lord, that is
Exhibit.
141 to
Exhibit
148 in your lordship's brief. My lord, we had to resort to this, my lord, in your lordship's brief itself. My lord, we had to resort to this practice because, my lord, the original I submitted before your lordship, even, my lord, these witnesses have deposed. My lord, this was xeroxed. It was annexed with your lordship's brief. And, my lord, thereafter, my lord, during this proceeding, my lord, those have been misplaced. So, as a secondary evidence, my lord, we had to mark this. My lord, all the parties consented to this.
Yes.
My lord, this is, my lord, so far the settlement agreement is concerned. My lord, my prayer C is with regard to this. My lord, this exhibit F. My lord, there it is mentioned as annexure I. My lord, page 24. Page 23, my lord, onwards, bottom portion of the 23. My lord is looking for the instrument, my lord. It is at page 141, dated 25th April 2023. 141.
This is F. Exhibit F.
Part of I. Dated, my lord, 25th April 2023. Yeah. Exhibit F, yes, my lord, exhibit F. Exhibit F.
This agreement, you are?
Lord, agreement, tripartite agreement, my lord, involving, my lord, Carewell, standard, my lord, I am saying standard, but my lord, standard is not a registered firm. My lord, that's why, my lord, two of the partners' name in the prayer, my lord, I have given. Because, my lord, that cannot be taken to be a juristic person. And, my lord, Shambhunath Ghosh, my lord, the sole Sebite and the sole trustee, my lord, who is surviving now. My lord, in the lineage of, my lord, the settler, Birendranath Ghosh, and, my lord, the subsequent trustee, Nirendranath. Now, my lord, this is, my lord, I am seeking, my lord, in terms of prayer C.
Yes.
And, my lord, I need to have, my lord, also, my lord, prayer D, my lord, which is annexure J, and also, my lord, exhibit J. My lord, at page, my lord, 149. না ওটা ডেট হবে না because that is
Yes.
Milord, this is no date, there is no stamp paper. Here, Milord, we are seeking approval of the terms pursuant to which, Milord, the parties will be formally entering into, Milord, this development agreement, because without your lordship's permission, they cannot. So, Milord, these two mainly, and my lord kindly observe, Milord, in the order, Milord, that the parties will enter into, Milord, development agreement in terms of, Milord, this exhibit J. Milord, one additional prayer I will be making before your lordship, Milord, considering this peculiar situation. Milord, to get back the exhibits, keeping, Milord, Xerox of the exhibits, so that the parties and the, Milord, departments act on, Milord, those original exhibits. Milord, exhibits, Milord, usually parties get
Accept.
back. Yeah. That is.
Apply for the certified copy, get that.
Then, my lord, kindly observe that, Milord, that the authorities and, Milord, otherwise authorities will, Milord, many a times when the plan is presented, Milord, they seek for, Milord, that. Development agreement will be in original with us, not that.
You obtain the certified copy of Exhibit F. Exhibit F is the agreement.
Exhibit F is there.
And development agreement is J.
J. Milord, the exhibit, Milord, 3 exhibits will be necessary. Milord, one is exhibit F, exhibit H, and, Milord, exhibit J.
Apply for that. Even
My lord, kindly observe that in the order that, Milord, all the parties and, Milord, also authorities and departments will act on the basis of those certified copies. That will suffice. Milord, one additional prayer, Milord, prayer E. My lord, kindly sees, Milord. Milord, for the, Milord, as of today, Milord, so far the trust goes, Milord, Shambhunath Ghosh is, Milord, aged about more than 70. Milord, he is the only, Milord, Sebaite and the trustee, Milord, who is remaining. Milord, the trust deed, if your lordship kindly comes to, Milord, at page 53. The relevant portion I'll be showing to your lordship only. Milord, trust deed provides, Milord, he has deposed also before your lordship. Milord, page 53.
What do you want? What is
Milord,
this?
I am seeking, Milord, that his lineage, Milord, his legal heiresses, Milord, in his absence will be, Milord, the wife and the daughter. None in the family. Milord, if by any chance anything happens, Milord, so that, Milord, they can, Milord, come into his place.
But what is the necessity of this prayer when the person is alive?
Milord, lordship kindly appreciate this. Milord, here in this case, Milord, property is going to be developed. Now, Milord, in page 53 of the trust deed, there is a condition, Milord, may I read that, which says, Milord, that after the death of the survivor, page 53, Milord, lordship kindly says. Just 5 or 6 lines, Milord, from the bottom of that page. After the death of the survivor of the said Nripendranath Ghosh, Milord, the father of, Milord, Shambhunath Ghosh, Milord, the petitioner before your lordship, and Mayarani Ghosh, the right of Sebaitship will devolve upon the lines of settler, the said Birendranath Ghosh and Nripendranath Ghosh, Milord, herein provided. Jointly provided.
Is this?
They will remain to be, Milord, the only heiresses. None else is there in the family. Milord, that pleading is there in the, Milord, petition. Milord, that's why, Milord, for abundant precaution, Milord.
What report?
Milord, if by any chance happens, Milord, all these investment and, Milord, the proceedings will be, Milord, absolutely.
Not now.
Very.
It is open to you, no? If
Lord,
by
can you
chance
keep
this
that?
happens, it is open to you to file an application seeking for modification of the order. Everything is. Ashun. And what will happen to the suit that is pending before the Howrah court?
That is, Milord, that, Milord, they are not proceeding with anymore. And that is one of the terms, Milord, in the settlement, Milord, that is to be abandoned.
This is an application seeking for following orders. Master submission, they can have it. The petitioner is the sole sebayat and trustee of the trust concerning DT Sri Sri Lakshmi Narayan Ji. The present application has been filed to settle long-standing dispute concerning the development of the property of the trust situated at premises number 24 Shastri Narendranath Ganguly Road, TS Shibpur, Howrah, 71104. Between the petitioner on one hand and Messrs. Carewell Properties, a registered partnership firm, and Kiran Patro and Sujit Kumar Rokhit alias Sujit Rokhit, carrying on business jointly as partners in the name and style of Messrs. Standard Construction. The entire management of the trust was initially entrusted with the official trustee of West Bengal. However, the daily Seva, Puja and festivities used to be maintained by the trustee and Sebayat, being the member of the Ghosh family, descendant of Birendranath Ghosh. By Justice Sengupta's order, that discharge of the trustee, official trustee, by order dated just now you have shown?
Yes. Well, at page 100.
By order dated
9th November 2000. No, below 9th November 2005 mentions that below official trustee is already discharged.
Okay.
And below official trustee was directed to hand over. Below that order is not with us.
Official trustee was discharged by the order of this court. And sole Sebayat and the petitioner. Petitioner, being the sole Sebayat, was appointed as the trustee.
Below, he was trustee by below Birendranath Ghosh himself during his lifetime. And since then,
Okay.
Birendranath Ghosh and Birendranath.
Sole Sebayat became the trustee as per the trust deed. The petitioner and Messrs. Carewell Properties entered into an agreement to develop the property. On which date, Mr. Ghosh? On such and such date.
না না কি আজে বাজে বলছো
Subsequent thereto, the petitioner filed an application before the court to develop the property through Messrs. Standard Construction.
Echo to that.
Being ATA 7 of 2013.
Yes, my lord, it was taken up by Shambhunath Ghosh, when, my lord, in favor of standard, the order was passed.
By order dated 9 September 2013, the property was directed to be handed over for development to Standard Construction, and it was further directed that on completion of construction of the flats, the same will be distributed between the promoters and the owners in the ratio of 60-40. Order of recall.
My lord, order of recall dated
Page number.
Yeah. Page 124. 29th August 2014 by Honorable Justice Patheri. (48) and 63.
By order dated 29th August 2014, the orders dated 2nd September 2013, 9 September 2013, and 16 September 2013 was set aside in GA 3695 of 2013. Messrs. Careable Properties. That suit before the Howrah Court is filed by the Careable.
Well,
Messrs. Careable Property also sought for execution of the agreement by filing a suit before the learned Civil Judge, Junior Division at Howrah, which is the court? Shivpur's first court.
Third Civil Judge.
Third court.
Third Civil Judge, Senior Division, Howrah. My lord, title suit number 440 of 2016.
Beginning 440 of 2016. Third court, Civil Judge, Senior Division. ঠিক আছে?
My instructions, my lord, they already have abandoned it.
In the meantime, the parties, namely the petitioner, Messrs. Careable Properties and Messrs. Standard Construction, has arrived at a settlement, which has led to the filing of the present application. Para. In support of the application, the petitioner, Mr. Shambhunath Ghosh, comma, Mr.
Development agreement and date due to liquidation.
Pradeep Singh. Pradeep Kumar Singh, one of the partners of Messrs. Carewell Properties, and Mr. Kiran Patro, one of the partners of Messrs. Standard Construction, deposed before this court. All of them have categorically stated before the court that the dispute amongst them have been settled, and they intend to enter into development agreement exhibit.
Well, that is exhibit J.
Exhibit J.
Well, settlement is exhibit F.
As well as they have also executed a settlement agreement which is marked as exhibit
F.
F. F. It master summons to দিতে বলুন তো। Since from the materials before this court, it is found that the parties have arrived at a settlement, let there be order in terms of prayer.
C.
Prayer C. A and B.
A and B will already granted. A was will
C. Okay. C. D of the notice of motion. Put a notice of motion. Okay? Notice of motion. Mr. Ghosh, learned advocate for the applicant, also prays for prayer E for an order granting liberty to the wife of the. Should I record this?
No, Lordship, may not.
Because if necessary.
Lord, as per the trustee, we also otherwise can proceed. And then
with the aforesaid observation, the application, what you GA2 of 2024 stands disposed of.
Lordship, kindly observe that. Lord,
all the parties are directed to act on the certified copy of the exhibits.
Fine, I am grateful. Parties and below the departments.
And the concerned departments.
Fine.
Okay.
Lord, ATA 4, this is so for the application. Otherwise, Lord, the moment your Lordship passes the order, Lord,
automatically it gets disposed of.
Good.
Good. Achha. In view of the above, ATA 4 of 2003 also stands disposed of. Is there any other prayer in ATA 4 which is to be decided by this court?
Lord, ATA 4, my lord, the order, the application was reconstructed. My lord, just a minute, so that we not know what the difficulty crops up.
A paragraph.
Yes, my lord, ATA 4, my lord, Lordship kindly sees, my lord, prayer C.
It reconstructed record to the
Or otherwise, my lord, it is not, because that is there in the, my lord, proposed development agreement.
So, with the settlement being arrived at between the parties, Mr. Ghosh seeks for disposal of ATA 4 of 2003. In view of the above, ATA 4 of 2003 stands disposed of.
My lord, so far, my lord, 2 dates of the development agreement earlier entered. My lord, Lordship has been pleased to keep the gap. My lord, I have given the dates. Now, 28th November 2003.
রেকর্ড একটু নিয়ে নিন, আমি পরে
Then
ওটা
11th
ইনকর্পোরেট
August
করব।
2004.
ওই স্লিপটা হারাবেন না, কারেকশনের সময় আমি ইনকর্পোরেট করব, ঠিক আছে?
আর কিছু চাওয়ার আছে?
আচ্ছা, মেন সুটা মানে ATA 4 of 2000।
Run-up and completion change.
ও আচ্ছা,
Concept of the party. My lord, this order, my lord, since we will act, my lord, the department may be directed to be drawn up and completed expeditiously. I'm grateful.
order be drawn up expeditiously.
And my lord, no, the direction teacher.
Yes. Next.
This is an application in the nature of Order 22, Rule 10, assignment of the interest, vesting of the right title and interest of the applicant, petitioner, applicant. Eight is a giant lamb too. Giant lamb. I will appear for the applicant. You move it. কোনো অসুবিধা নেই।
My lord,
না না, আমার দেখে নি ওপরে।
My lord, it's an application for recording of assignment of a trademark. Lord, but since the suit is in regards to passing of a trademark, and after the constitution of IPRD division, the exclusive jurisdiction is remains with the
View of
IPRD.
the notification. Notification. Give the copy. In view of the notification. This is the roster. There is a notification of the High Court. In view of the notification, number 2281G, dated 2nd July 2024, the suit pertaining to intellectual property is to be tried by Intellectual Property Division within bracket IPRD. A registrar original site, next line, register original site, accordingly register original site is directed to take appropriate steps. The matter is released from my list, from minor, from the list of this court. Yes.
Grateful, my lord.
Any. চলো।